get that leave, my lord, from your lordship.
Which date?
The 20th of March, your lordship was pleased to pass in.
Oh.
My lord, I'm appearing for the defendants number 1 and 2 in this suit, my lord. Thanks.
Returning. Yes.
And I'm praying for extension of time of the mandate of the commissioner who is taking evidence, my lord. My lord, on 31st January, extension was granted up to 2nd April, which is today, my lord. My lord, my witness will start, my lord. I'm the defendant. A little time would be needed, my lord.
Which for the other side?
My lord, my plaint.
Your witness, you are for the defendant?
I'm for the defendant.
Your witness has not yet started?
No, not yet started, my lord.
How many witnesses you are having?
My lord, at the most 2 witnesses, my lord.
2 witnesses. Yes.
3 months, I believe
Yes,
it will
Lord,
be.
3 months.
3
There are
months.
2 witnesses, 3 months would be.
2 witnesses, 3 months. I will dispose of within 2 weeks.
My lords are faster, my lord. I have seen.
Suffering for the plaintiff, suffering for the defendant. Full stop. Counsel for the defendant submit that. The matter is fixed today for the matter is fixed today for filing report by the advocate commissioner. For the counsel for the defendant submit that. The plaintiff witness has been closed and the defendant is to adduce their evidence, and as such, counsel for the defendant prays for extension of time to file report by the commissioner. Counsel for the defendant submitted the defendant intend to adduce 2 witnesses on their behalf. Consider the submission made by the counsel for the parties. Time to file report by the commissioner is extended for a further period of 3 months from date. Full stop. That the commissioner is directed to file report before this court on 10th June 2025.
My lord, only one humble submission. My lord has been pleased to record that 2 witnesses evidence. My lord, we propose to, provided my lord.
Intents.
Great.
On behalf of the respondent, my senior I'm on behalf of the respondent, my senior is on the way. In the meantime, I can file the affidavit in opposition and supplementary affidavit.
Who is for the plaintiff? You are for the defendant?
Yes.
What is the application for? What application filed? The plaintiff filed application?
It has already been served to the opposite party.
CS 51 win. So it is filed with the defendant. You are for the?
I for the defendant.
You have filed the application. Humble petition of the defendant, GA2. GA2. For stay or dismiss the stay permanently.
Yes, for GA2, I will file the supplementary affidavit. For GA2, I am filing supplementary affidavit. It has been already.
Leave is granted.
Yes, sir.
Any leave was granted to file supplementary affidavit. 3rd March. None appears on behalf of the plaintiff.
I am sorry, but I'm appearing for the defendant. My application. I'm sorry, but I'm appearing virtually. Starting the jam. I'm sorry.
No problem. No problem. Who is for the plaintiff?
Mr. Ghosh was appearing for the plaintiff, but my lord, we don't know now who is appearing. The last occasion also they didn't appear, so my lord, we don't know that.
So your junior telling that you want to file the supplementary affidavit?
Yes, my lord, the supplementary affidavit.
For what?
Okay, my lord, fixes, but not nowadays. My lord, later on, any day, my lord. Kindly, my lord. Is it new to the bar? That's the reason, my lord, I'm coming and assisting, my lord. Otherwise, I would.
Okay, not today.
The bar, therefore, my lord.
So this is my just come at my stream. Yesterday I wanted to file the settlement, my lord. But there are 2 suits, my lord. Item number 3 and 4. My suit is for recovery of money, my lord, and their suit is for 3 and 4, my lord.
3 and 4. CS 52 and?
Yes. The CS 423 new company and 766, my lord.
Yes.
Now the parties have agreed. It's your lordship only appoint the name of the arbitrator, my lord. Okay. I'm telling you.
Yes.
And Mr. Avasti is also here.
Yes, sir. I agree.
Ready?
Yes, sir.
Both are claim and cross. So,
Yes,
suit
sir.
and
My
cross.
suit is for recovery of money, their suit is for really for damage, claiming damage, my lord.
So appearing for the plaintiff
Defending
in
the charge.
CS Com 766 of 2024 and
Sir, the
so
reverse code.
appearing for the defendant. In the present suit, the plaintiff has prayed for decree for a sum of rupees 5,95,72,091 along with the interest at the rate of 18% per annum. दूसरा वाला दो. Consistency of for the plaintiff in CS Com 423 of 2024 and so appearing for the difference will declare different. In the present suit, in this suit, the plaintiff has prayed for a sum of rupees 1,21,45,767 along with interest at the rate of 18% per annum. Counsel for both the counsel for the respective parties of both the suits submit that both the parties have taken a conscious decision for referring the matter to an arbitrator. To an arbitrator. Counsel for the parties submit that for the purpose of determination and adjudication of the differences and disputes arising of CS Com 423 of 2024 and CS Com 766 of 2024 be referred to the arbitrator. Consider the submission number next. Consider the submission made by the counsel for the respective parties. As both the parties have agreed to refer the matter to the arbitration, to the arbitrator to settle the dispute between the parties. To adjudicate the claim. To adjudicate the claim between the parties. Accordingly. Yes, any judge? Retired judge?
As the lordship pleases.
But my claim is about 1 crore or plus. He says he has a damages of more than 5 crores.
So, accordingly, Mr. Justice Subrato Talukdar, a retired justice of this court, is appointed.
Incidentally, my lord, he is in session of another dispute between the same party. But I was just thinking aloud. Your lordship has named the same person, my lord.
Small word.
There is no problem.
No, my lord, he is already there in other matter, my lord.
Connected up.
Subrato Talukdar, retired justice of this court, is appointed as arbitrator. To decide the dispute between the parties in accordance with law. Full stop. The arbitrator shall raise his remuneration in terms of Schedule 4 of the Arbitration Cancellation Act. In view of the above, CS numbers and so disposed of.
But in my learned friend's suit, my lord, the wakalatnama could not be filed. It is ready, my lord, executed. My lord, can it be filed in the department or lordship can accept it?
Who?
In my learned friend's suit, my lord, my wakalatnama.
Defendant in
They could not
CS
file the
numbers
statement.
423.
That is all over.
423.
Lord,
The time to file was over. That is the thing.
lord, this is of course
Second
commercial suit, my lord.
First. 766 is
766, my lord.
You are the defendant.
I am the defendant.
देख लेना Counsel for the defendant in
Digital.
CS.Com 766
66
of 2024 is given liberty to file wakalatnama in course of the day in the
in the
department.
department, Lord. Developed.
A perfect example of what we say, my lords know everything. So in another matter, same arbitrator was there without even indicating, my lord gave the same arbitrator.
It is better to the parties also.
But we did not that Lordship will name the same person.
Yes, sir. Very, whatever fallen from your
Roman.
oblige, man.
Thank you.
Lordship, this matter had appeared yesterday and was adjourned because I was not equipped with the date of e-filing of the suit. And I have to satisfy Lordship on the issue of limitation.
Yes.
May I have your Lordship's kind leave to just submit a short list of dates? Lordship, the ledger statement shows annexed at annexure H at the last page that the last date of payment made by the defendant is 20 November 2021.
20 November
2021.
10 lakhs. 10 what?
10,000.
10,000.
Part payment made against the outstanding dues in total. Thereafter, Lordship, the period between 15th of March 2020 and 28th of February 2022 was excluded by the order of the
So
Honorable
20,
Supreme Court.
20 March, 21st, 20th January, November 2021, the last payment was made.
Yes, yes.
So your cause of action was 21, 22, 22, 23, 23, 24. 24th
Yes,
November 2020.
normally. And due to the exclusion of the period between 15th of March 2020 and 28th of February 2022, this entire period till 1st of March 2022 remained excluded. So the actual limitation calculation starts on and from 1st of March 2022.
Correct.
Thereafter, we had 3 years to institute the present suit. So the 3 years period expired on 28th of February 2025.
Correct.
This year. The suit court fee payment was made thereafter, which is 6th of March 2025, as I've indicated in the list of dates. The e-filing was done on 12th of March 2025.
What payment was made?
The court fee payment online
Court fee payment was made?
on 5th of March. It's annexed with the plaint as
5th
well.
of March, appropriate court fee deposited by the plaintiff. Yes.
Then 12th of March 2025, the suit was e-filed at the first instance. The physical filing was on the 13th of March 2025, after which the department raised certain affirmation issues, certain documents. Those were reaffirmed, refiled on 21st of March 2025 online, and then final physical filing and numbering and registration happened on 24th of March 2025. So, if we just exclude the period of the COVID, then the suit is time barred. But then there is a clause, Lordship is aware, the proviso to section 12A of the Commercial Codes Act, which provides that the time period for which the parties were engaged or occupied in the mediation process, that will not be computed for the purpose of limitation. So I've indicated the period. Lordship kindly takes the second page, 1st October 2024 to 10th of December 2024, which is 71 days. Because the mediation was filed on 1st of October 2024 and the non-starter report was furnished on 10th of December 2024. So 71 days additional is to be calculated in the period of limitation. So since the limitation would have expired on 1st of March 2025, we get more 71 days from then, because that is the period when the parties were engaged in the mediation. So therefore, Lordship, my humble submission is that even if we take the final date of registration of the suit after multiple e-filing and physical filing, which is on 24th of March 2025, we would still have additional 48 days remaining for filing the instant suit.
What is happening after the electronic filing?
Lordship, what is happening is that the electronic filing is done. Then the department, after we deposit the physical copy with the department, is actually scrutinizing the plaint. So in this particular case, I'll just...
What is happening to the e-filing? You file the e-filing.
Yes.
What is happening about that? The e-filing? What will happen about the e-filing?
Lordship, I'm not able to understand the question.
You have filed the e-filing on 12th March.
Yes.
Correct.
Yes, I have annexed the
And subsequently you have filed on 13th March the physical copy.
Yes.
So what has happened to the e-filing record? What is happening in the e-filing
I have
record?
added the receipt on the next
You
page.
have added the what is happening that e-filing record? It is in the only.
It is on the website.
That's all.
It is supposed to be available with my lords for reference online.
Yeah.
It is supposed to be, my lord.
Huh? No, numbers will be same, but so what you have prayed for?
My lord, leave under clause 12 of the letters patent
Why?
because the defendant is outside jurisdiction.
That's all.
But yes, that's all. The
So and so offering for the plaintiff. So and the plaintiff has filed the present suit, praying for a decree for a sum of rupees 14,09,313 along with interest at the rate of 9% per annum. Counsel for the plaintiff submitted. The plaintiff is within the jurisdiction of this court and the defendant is outside the jurisdiction of this court. Accordingly, the plaintiff has prayed for leave under clause 12 of the latest patent. Consider the submission made by the counsel for the plaintiff. Peruse the materials on record. This court find that the defendant is outside the jurisdiction of this court and accordingly leave under clause 12 of the latest patent is granted. Plaintiff is admitted subject to scrutiny by the defendant.
grateful. Grateful, Lordship. Lordship, item number 6 is also the same.
Yes, item number 6 also.
Yes, I have a list of dates for the same issue.
Same issue.
Yes.
So and so offering for the plaintiff. The plaintiff has filed the present suit, praying for leave under clause 12. No, I am praying for a decrease for a sum of rupees 15,44,096 along with interest at the rate of 24% per annum. Counsel for the plaintiff submitted. The plaintiff is within the jurisdiction of this court and the defendant is outside the jurisdiction of this court. Unless some cause of action arose within and some cause of action arose outside the jurisdiction of the court and prayed for leave under clause 12 of the latest patent. Had the learned counsel for the plaintiff peruse the materials of plaint, peruse the plaint and the materials on record. Leave under clause 12 of the latest patent is granted. Plaint is admitted subject to scrutiny.
Grateful.
Your Lordship, I am appearing on behalf of the plaintiff in this matter. We have taken necessary instruction. We would like to withdraw the plaint and will go for mediation. In the meantime, kindly allow us to withdraw the court fees we have paid.
Good. So and so opening for the plaintiff. Plaintiff prays for leave to withdraw the suit with liberty to file the suit before the appropriate court. Counsel for the plaintiff also prayed for counsel for the plaintiff prays for leave to withdraw the suit withdraw the suit so as to enable the plaintiff to institute pre-mediation process before filing of the suit. Counsel for the plaintiff also prayed for a refund of the court fee. At the learned counsel for the petition plaintiff, leave is granted to the plaintiff to withdraw the suit. Suit accordingly, CS Com 42 of 2025 is dismissed as withdrawn. Liberty to take appropriate steps for pre-institution mediation process, and on completion of the same, if any occasion arise, the plaintiff has the liberty to file afresh before the appropriate forum. The department is directed to refund the court fee, and the plaintiff has the liberty to use the court fee if any occasion arise to file a suit after the completion of mediation process.
Obligation.
My lord, this is I appear for the plaintiff. It's a money claim where your lordship has given us interim protection pursuant to your lordship's direction. We have served the writ of summons. One defendant has been served by substituted service. We have filed affidavit of service. On the last occasion, your lordship had given us time to obtain report for from the department for non-appearance. We have written a letter to this department, but normally we are given the report. But my clerk says that it is sent to the court. This never happens. Perhaps they have sent it to your lordship. I've given the letter on, the letter is with me on 25th March.
When the notice, the writ of summons was served?
It is recorded in the order 7th March 2025. 14 February 2025, the last defendant was served, defendant number 2 by substituted service. And the other defendants were served earlier. It's recorded in the order, your lordship's order dated January 7, 2025.
None appears.
Yes.
So appearing for the plaintiff. None appears on behalf of the defendant. The registrar, original side of this court, has submitted the report wherein it reveals that defendants have not entered appearance till 26th of March 2025, and as per the record available with the department, no written statement has been filed. It is fine from the record. The writ of summons were duly served upon the defendants. No, and paper publications were also made, no?
For defendant number 2 only, because
upon the defendants. And with regard to service of notice upon the defendant number 2, paper publications were also made, but in spite of the same, none appears on behalf of the defendants. Accordingly, CS Form 4 of 2024 be placed in the list of undefendant suit. Full stop. The plaintiff is directed to file the judge's brief of document within 2 weeks.
Give me a little more time.
Within 4 weeks from date.
Yes.
Full stop. The plaintiff is also directed to file the examination chief affidavit of evidence of the plaintiff witness within 2 weeks thereafter. Give the date after 6 weeks for witness action. Today April, na? May last year June first week. 10th June में है 10th June at 2 p.m.
10th June.
10th June 2 p.m. witness X.
Deeply.
Next.
Lordship, this is my application, Your Lordship. I am the plaintiff in this instant suit. This is a commercial suit filed by me against the defendants for mean profit and for other reliefs. Lordship, what happened? My witness examination was concluded, and by way of commissioning, there is a commission already appointed by this honorable court. On 13th January 2025, the commissioner directed or requested them to file their affidavit of evidence. This was the third instance. They did not file within 7 days. On 29th January, when the matter appeared for filing of report by the commissioner, they then sought time, 1 week. The honorable court directed them. They did not file. We filed this application for closing their witness in February. The matter appeared on 4th March. Your Lordship would kindly see the order, did not appear on 4th March. 6th March. And your Lordship was pleased to fix today, in the interim period, they have filed their affidavit of evidence. Now, Your Lordship, since they have filed their affidavit of evidence, Your Lordship, I pray for some cause because this is a commercial suit, Your Lordship. I cannot stand in the way of filing in the affidavit of evidence. But since my application is already on board, all I pray is for some cost because I being the plaintiff is actually the suit is getting delayed at their instance.
When you file the examination chief?
29th of March.
29th of
March.
March.
Kindly sees your lordship page 54 of my application, your lordship. I've just placed 2 documents just to show their conduct.
May I, my lord?
Just
Yes,
I will
let me place
hear
two
you.
documents.
I will hear
Yes,
you. No problem. Page 52.
Page 54, your lordship.
my lordship. That is why my lordship will not find it in that. But what is appearing in the list today, my lord, is GA2. And my learned friend has made entire submission, my lord, with regard to GA6, my lord, which has already been disposed of. What is there in your lordship's hand, my lord, is GA2, which is an injunction application
Yes,
filed by my
GA6 is
lord.
disposed of
Yes.
by an order dated 6th March.
GA6 has already been disposed of.
GA6 is disposed of. Matter will appear on 2nd. The commission is directed to finish the witness action on the date that is 31st of March 2025. The matter will appear in the list on 2nd April as it was fixed earlier.
GA6 is not. No.
Witness action shall be expedited in proper manner. Affidavit and evidence shall be served in advance to the respective counsels. Affidavit in evidence of development shall be filed within 1 week from today.
Yes.
With an affidavit copy of the adversary report.
That is the order of 24th January, your lordship.
Correct. 29
They filed on 29th March.
29 January. And 26th March, 6th March, court has fixed the cutoff date of 31st of March. So where is the report of the commissioner?
Lordship, they are yet to file. They have served me with an
They are not filed.
May I, my lord, make my submission?
Yes.
My lord, lordship will kindly see, my lord. On 29th of January 2025, my lord, an order was made, my lord, and we were supposed to file it, my lord, within a week, my lord. Lord, admitted position, my lord, we did not, my lord.
Correct.
Next, my lord, they take out an application, my lord, which is GA6 and which is disposed of.
What is the GF6? What was the prayer?
GA6 to close our evidence, my lord. So, my lord, the honorable judge, my lord, deemed it fit, my lord, to not close my evidence, my lord, and the my lord, the application was disposed of. And my lord, in normal course, my lord, the 31st January, my lord, deadline was in terms of the earlier order, my lord. That it has to be completed by 31st. So, my lord, the honorable judge, my lord, thought it deemed fit, my lord, that since the date is already there, let the date be there. Now, my lord, before 31st of March 2025, my lord, the affidavit in chief was filed, my lord, but not in terms of, my lord, the order passed by this court, my lord, there was a delay. Now, if your lordship sees, my lord, the order of 6th of March, my lord, we have not appeared. The reason being, my lord, my advocate record, my lord, did not have any instructions, my lord, from the company whether to appear or not, whether to oppose or not. Lord, so we did not appear. The reason which we came to know later, my lord, is that the person who is supposed to depose, who is supposed to come and affirm, and the person in control and management of, my lord, the company, my lord, his mother had expired on 22nd of February 2025. And before that, my lord, as per him, my lord, he was running from hospital to hospital. Therefore, my lord, he was not in a position, my lord, to come and affirm. Ultimately affirmed on 29th of March and served upon them, my lord. Be that as it may, my lord. Be that as it may, my lord. It is my humble prayer, my lord, and I would second the prayer of my learned friend, my lord, that some cost, my lord, should be imposed. Because there has been, my lord, delay and latches on the part of the defendant, my lord. Since your lordship would be extending the time, my lord, since the affidavit has been filed, my lord, lordship, my lord, even if it's notional, but some cost, my lord, should be imposed on my client, my lord.
Your lordship, they are yet to file their affidavit in April.
You're not
that is before the commissioner.
You're not served the commissioner?
Yes, yes, sir.
So when your witness will be available before the commissioner?
Yes. Let a time be.
That's why I'm telling.
Yes.
When your witness will be available before the commissioner?
Lordship,
how many witnesses you will give?
Two.
Two witnesses.
That should be, my lord, over within a month, my lord. If your lordship extends by a month, my lord, I think, my lord, it should be over.
So and so appearing for the plaintiff, so and so appearing for the defendant. In terms of the order passed by this court dated 6th of March 2025, the advocate commissioner is required to file report Full stop. Counsel for the plaintiff submitted that by an order dated 29th of January 2025, this court has granted liberty to the advocate and to the defendant to file the evidence of the DW1 within a week from 29th of January 2025. But the defendant has not filed the affidavit of the defendant's witness number 1. Accordingly, the plaintiff has taken out an application being GA6 of 2025, praying for closing of the evidence of the defendant. This court, by an order dated 6th of March 2025, has disposed of the said application by fixing a cutoff date on 31st of March 2025. Full stop. Today, when the matter is taken up for hearing, the counsel for the plaintiff submitted that the defendant has not filed any and not served any copy or not filed either the evidence, has not filed the evidence of the defendant witness number 1. Full stop. And he prays for closing of the evidence.
That is not his submission. That is not his submission. We've served them on 29th.
Served.
Yes.
He's telling them not served. Counsel for the plaintiff submitted that the evidence of plaintiff submitted the copy of counsel for the plaintiff submitted that the defendant has served the evidence of the DW1 only on 29th of March 2025, but the same has not filed before the commissioner.
The commissioner has also been soft copy has been served upon the commissioner.
They have not filed. Okay, filed on 29th of March 2025. Full stop. Counsel for the defendant submitted that due to some personal difficulties of the defendant could not file the affidavit of evidence in terms of the order passed by this court and prays for extension of time to conclude the evidence of the defendant witness. Full stop. At the learned counsel for the respective parties, this court find that the defendant has served the copy of the affidavit of evidence of the DW1 to the learned counsel for the plaintiff on 29th of March 2025. And the counsel for the defendant submit that he will adduce only 2 witnesses in the support of the case of the defendant. Accordingly, for the interest of justice, time to file report by the commissioner is extended for a further period of 4 weeks from date. Full stop. In the meantime, the defendant is directed to produce the witness before the learned commissioner so that the evidence of the defendant witness can be completed. And the advocate commission is directed to submit the report before this court. Before this court on 7th of May 2025. It is made clear that no further opportunity shall be given to the defendant if the defendant failed to produce the witness before the commission.
Lodge.
Let's renew my prayer for some costs.
I had volunteered.
Your Lordship, item number 10, I'm for the plaintiff. Till now we have not received the written statement, and this is an application filed by the defendant.
Who is for the defendant? Who filed this? Copy not served. Sormi Datto. So appearing for the plaintiff. None appears on behalf of the defendant. Defendant has filed an application being GA-Com 3 of 2025, praying for extension of time to file return statement. As none appears on behalf of the defendant, for the interest of justice, the case is adjourned. Let the matter appear on 4th of April 2025 under the same heading. It is made clear that on the date fixed, if the defendant failed to appear and move the application, appropriate order will be passed.
Grateful. About item number 11, I'm for the plaintiff respondent. I'm being led by Mr. Banerjee.
I'm appearing for the respondent in this application. GF4 is listed today, Your Lordship. If your lordship kindly takes your lordship's last order dated 21st of March 2025, your lordship was already pleased to list this suit as in the undefended list, your lordship. Apropos the failure, yes. Apropos the failure on the part of the respondent defendant to file their written statement. Now, in this GA4 has been filed for return of the plaint, rejection of the plaint on account of non-service of the writ of summons. If your lordship kindly takes the pleadings in GA4,
Yes.
your lordship will kindly take para 15 onwards at page 6. Your lordship recalls the argument that the writ of summons was not served properly on the defendant since the defendant was situated outside the jurisdiction of this court was made in course of the hearing of the application for extension of time to file written statement. They had relied upon Rule 5, Rule 6, etc. of Order 6 to Order 9, Chapter 9 for the proposition that the writ of summons should have been served only with the order of the court. Now, apropos that, I had also made submissions. Your lordships will kindly see para 15, 16, 17, and 18. The entire cause of action in this GA4 is one of non-service of the writ of summons in accordance with the code and other rules.
Yes.
Now, your lordship will kindly take your lordship's order dated 3rd of March 2025.
Yes.
In my submission, this issue is entirely decided and entirely covered by your lordship's order, because this submission was made in course of the arguments of GA3. Your lordship will kindly take page 4, the 3rd paragraph.
Yes.
This was my submission.
Yes.
Your lordship has found that counsel for the plaintiff submits that the writ of summons sent to the defendant through speed post was also received by the defendant on 30th March 2024. The plaintiff has relied upon Chapter 6, Rule 12 of the original side rules of this court and submits that in terms of the original side rules of the court, the registrar or master may conduct all such businesses and exercises, and all such authority and jurisdiction under the rule may be transacted or exercised by the judge in chambers except where otherwise prescribed. Accordingly, the writ of summons upon the defendant was sent as per the order of the learned master by both ways, and thus it cannot be said that the writ of summons sent to the defendant through the speed post is not good service. Now, apropos this, your lordship, your lordship will kindly...
Which paragraph you
Para 7. Page 6, 3rd paragraph. Page 4, 3rd paragraph. I'm sorry, your lordship. Page 4, 3rd.
Yes.
Counsel for the plaintiff submits. That is my submission. Now, your lordship will kindly take page 7.
Yes.
This is the finding, your lordship. In terms of the provisions of the original side rules, the registrar or master of this court exercising all such authority and jurisdiction under this rule. Accordingly, the master has issued writ of summons upon the defendant through district judge of Cuttack, Orissa, and also sent through speed post. Thus, the judgment relied by the defendant is not applicable in the present case.
Yes.
Then, page 8, your lordship, the 2nd paragraph. In the present case, the writ of summons was served upon the defendant through the process server, so-and-so, and the writ of summons through the speed post was duly served. No written statement is filed. So there is a categorical finding on this issue in your lordship's order dated 3rd of March 2025. Now, it is my humble submission that in view of this finding and this argument made in course of the hearing of GA3, nothing remains to be decided. This entire issue is res judicata. Recourse, if any, on the part of the defendant would lie in appeal, your lordship. And this application, your lordship will kindly see, was filed subsequent to this order. This application has been filed on or about 10th of March 2025. Whereas this order was of 3rd of March 2025.
Whether this order is a challenge, 3rd March order is under challenge? No.
Not to our knowledge, your lordship. We have filed caveat, we have lodged caveat, but no challenge yet.
Okay.
So in such circumstance, nothing remains to be decided in GA4. GA4 has become infructuous GA4 should be dismissed as being rendered infructuous and barred by res judicata, Your Lordship. That is my humble submission.
Resolution नहीं नहीं so appearing for the plaintiff, none appears on behalf of the defendant. Defendant has filed an application being GA Com 4 of 2025, praying for an order for rejection of plaint being CS Com number 564 of 2024, or for dismissal of the suit. The defendant has filed the present application on the ground that the writ of summons was served upon the defendant on when it was served through post
30th of March.
On 30th of March 2025 through postal services, but there is no order of this court for sending the writ of summons through speed post or / postal services, and as such the service of writ of summons upon the defendant through postal services is bad in law, and as such the date of service upon the defendant and date of service of writ of summons upon the defendant dated 30th March 2020 cannot be taken into consideration.
May I just interject for once, Your Lordship?
Yes,
With Your Lordship's permission. They claim that even 16th May and 30th March both are invalid because it was not
already
but that's it, Your Lordship.
Counsel for the defendant the defendant has also taken the stand in the present application that even though the writ of summons served upon the defendant on 16th May 2024 cannot be taken as a deemed as a proper service, as a proper service, that the plaintiff has not obtained appropriate direction from this court for issuance of writ of summons. Counsel for next para. Per contra learned advocate appearing for the plaintiff submit that the issue raised by the defendant in the present application is already decided by this court by an order dated 3rd of March 2025. Counsel for the plaintiff has drawn the attention of this court to the order dated 3rd of March 2025, wherein the submission of the defendant was recorded as follows. Page 4, 3rd paragraph. Italic बीच में आएगा.
That is my submission, Your Lordship.
Single
the defendant's submission is at page 2.
Just a minute. Yeah. Paragraph page 1, page 2.
The bottom paragraph. The bottom paragraph.
This paragraph, page 2, paragraph 3rd paragraph, page 3, page 2, paragraph 3, यहाँ से यहाँ तक का है, ठीक है. Learned counsel for the plaintiff further draw the attention of this court to the submission made by the learned counsel for the plaintiff in the said application, which reads as follows. Page 4, 2nd paragraph. Okay. Full stop. Counsel for the plaintiff submit that this court has decided the said issue by an order dated 3rd of March 2025 by holding that paragraph 7, page 7, paragraph 2, and page 8, paragraph this one. First paragraph, this यहाँ से यहाँ तक का, full नहीं आएगा, यहाँ से यहाँ तक आएगा, ठीक है, सब पैरा. Had the learned counsel for the plaintiff peruse the pleadings of made in CS Com 4 of 2025 and the order passed by this court dated 3rd of March 2025. This court find that initially the defendant has filed an application being GA Com 3 of 2024 praying for extension of time for filing return statement. This said application was disposed of by an order dated 3rd March 2025. In this said application also, at the time of hearing of the said application also, the defendant has taken the similar ground that the writ of summons which was served through the postal services was not in accordance with law, as there was no order passed by this court, and the writ of summons was served upon the defendant through the learned district judge of Orissa was also not in accordance with law, as there was no order from this court. This court, by an order dated 3rd March 2025, have decided the issue and come to the conclusion that in terms of the provisions of the original said rules, the registrar or master of this court, exercising all such authority and jurisdiction under the said rule, the master has issued the writ of summons upon the defendant through the district judge of the Cuttack, Orissa, and also sent the writ of summons through the speed post. And as such, and this court has refused to grant time for extension of grant time to file written statement to the defendant. Full stop. Considering the above, this court find that this court has already decided the issue, and in spite of having the this court find that the order was passed on 3rd March 2025, deciding the issue that the writ of summons served upon the defendant in both the ways, that is through the process server, through the district court of Orissa, Cuttack, as well as through the postal services, are in accordance with law. But in spite of having the knowledge, on 12th of March 2025, the defendant has filed the present application. Taking into consideration the above act of the defendant, this court find that only to kill the time and to delay the matter has filed the present application. Accordingly, this court find that the application filed by the defendant is misconceived. Full stop. GA Com 4 of 2025 is dismissed. No order is cost.
I'm very deeply obliged, Your Lordship. The writ of summons were issued in 2024. Perhaps Your Lordship will kindly look at that.
I will check it.
Your Lordship
writ of summons was served on
24. Your Lordship has perhaps dictated 25. But
okay,
I'll leave that to Your Lordship. I'll leave that to Your Lordship. I'm very deeply obliged.
Both the application?
11 and 12.
11 and 12, Your Lordship.
11 and 12.
Identical.
11 serial and 12 both order.
Grateful.
Very deeply obliged.
दो सूट है दो ऑर्डर हो.
And for the plaintiff,
I appear for the respondent number 1.
Yes.
I had commenced my arguments in this matter. Your Lordship recollects. This is a suit for declaration
yes.
and injunction. Before I start, my lord, I must tell your Lordship, my lord, an impression is sought to be given that I'm running away from the matter.
No.
This has never happened, my lord, in my 24 years.
Thakka,
You're very unfortunate, my lord. These kind of submissions are made.
With regard to one advocate who wants the matters to be disposed early, one advocate is taking time, they may, but this court is not taking cognizance on that.
Please, my lord, that is all, my lord. Now, your Lordship kindly takes the plaint once, please. Kindly see the relief sought in the plaint.
Yes.
Relief sought in the plaint, my lord, are simpliciter, declaration, and injunction. Declaration that the defendant number 1, now, my lord, kindly see, declaration that the defendant number 1 is entitled to a sum of rupees 1 crores odd in the particulars given in paragraph 22 above, being his share in the amount payable to the erstwhile senior partner of the plaintiff number 1, late Dinabandhu Mandal, in terms of clause 17 of the partnership deed. So, my lord, prayer A itself contemplates two findings, my lord, before the suit can be decreed. This is a primary prayer. The rest are all consequential or ancillary or connected with this. One is that clause 17 of the partnership deed applies. That is the first finding which has to be returned. Second finding has to be returned is that this amount of 1 crore 7 lakhs, particulars whereof are given in paragraph 22 above, is the only amount which is to be paid in terms of the determination in clause 17. This is the sum and substance of the suit. Now, my lord, a suit for declaration and injunction is filed. Kindly have the Specific Relief Act once now, please, my lord. This relief, your lordship kindly sees, the plaintiff is not entitled to ask for as a matter of right.
Why?
Kindly see section 34. He is not entitled to ask for this relief as a matter of right. It is an entirely discretionary relief, which I'll show your lordship in the facts of this case, should not be granted, whether at trial or whether at Order 8 Rule 10 stage. Order 8 Rule 10, I'll address your lordship, my lord, why it should not be granted. But this is a relief which should not be granted even at the stage of final trial. Kindly see section 34.
Yes.
Declaratory decrees. Any section 34, discretion of court as to declaration of status or right.
Yes.
Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief, provided that no court shall make any such declaration where the plaintiff being able to seek further relief than a mere declaration of title omits to do so. An explanation we are not concerned with. So, number one, even if this section applies, and I'll show your lordship why this declaration can never be granted, because this declaration, as your lordship has seen, prayer A, is not declaration of any right or title or character of the plaintiff. It is a declaration of a right, title, character of the defendant. A person entitled to any legal character or to any right as to any property. Now kindly see prayer A. Has nothing to do with declaration of right of plaintiff. Has the entire suit is for declaration of my rights.
Entitled to any character or any right as to any property. Yes.
So, my lord, it is
any person.
Yes.
Denying or yes.
Correct. So, my lord, it has to be a declaration, a positive declaration which the plaintiff seeks of his right.
Yes.
If I had filed the suit, my lord, and if somebody was not, if the defendant was not paying me these monies, and I had filed the suit that in terms of section 17 of the partnership deed, I am entitled to so much, I need not have even sought a declaration. I would have sought a simpliciter money decree.
Yes.
But the declaratory relief which is provided is for a positive declaration affecting one's own character and right. Any person entitled to any legal character. Well, kindly see prayer A now. Prayer A does not say that the plaintiff is entitled to any legal character. That is the first necessity of a suit for declaration. That I am entitled to something, somebody is casting a cloud on my title. None of these reliefs relate to any right of the plaintiff.
Yes. Yes. Next.
Second, even if, now Malad, the law is, and I'm sure Malad, people, the plaintiff will come and say that the circumstances which are given in 34 are not exhaustive. Specific Relief Act is not an exhaustive act. So the circumstances given in 34, that is legal character, right to any property, these are not exhaustive. That is correct. But what is exhaustive is that the declaration must be sought of the plaintiff's rights, not of the defendant's rights. That is the point which I'm trying to make. Judgments will be shown to your lordship, and that is the right law also, that it is not only limited to declare legal character or right to any property. There can be declarations for other things also, but that declaration must be qua the plaintiff himself. A person cannot come to court and say that X does not have any right, or X's right is limited to this only, please declare this. He must seek a positive declaration of his right on any matter whatsoever, not of X's right. The suit as framed is for declaration of my rights, which it does not lie in his mouth to seek. So A, the suit as framed for declaration is not maintainable. As it is hit by section 34, it seeks declaration of the defendant's rights, which is not contemplated in the specific relief act or any other law for that matter.
Yes.
Second, even if the suit as framed is maintainable, that he can come and seek defendant's rights, which I, with the greatest of respect, I say it is not maintainable. Even if it is maintainable, he is not entitled to as a matter of right, because the court may in its discretion make such a declaration. Correct. So the court is not bound to give him a declaration that yes, the defendant's right is this. Then the question arises, in what cases do your lordships exercise this discretion? It's not arbitrary, it's after all an exercise of judicial conscience. So in what cases do your lordships exercise this discretion? Now may I trouble your lordship with these judgments? Kindly have the Guwahati Dawage. I'm starting with a High Court decision, and I'll show your lordship how the High Court decision is very comprehensive and has been approved by the Supreme Court also. It's of the Guwahati High Court, 53 Guwahati. In cases of suits for declaration, when the courts have held that declaratory reliefs are not to be granted for the asking, the court must be satisfied that great injustice will be done if the declaration as sought for is not granted. And the courts refrain from granting declaratory relief.
Correct. So that's okay. If we go by that also,
please,
okay, they are ready to give 1 crore 7 lakh, whatever the other legal also accepted. You're not bound. You're not bound.
Yes.
But they have agreed to give it.
Then I ask myself, yes, your lordship will finish. I'm sorry.
Correct. And you have not accepted that.
Yes.
But you have not given any reason, and what is your claim?
Yes, my lord.
That is one of the aspects.
Yes, one of the. Now, my lord, kindly see that is why I'll these kind of declaratory reliefs, the specific relief act in its entirety is a doctrine of equity. He admits that he owes me 1 crore rupees. He is not a layman. He has, according to his calculation, 1 crore 7 lakhs is payable. Doctrine of equity would have demanded that 1 crore 7 lakhs would have been deposited in court in an interest-bearing account on the day the suit was filed. Making an application, making an offer is not showing equity. 1 crore 7 lakhs would have been paid to me, saying that this is full and final payment. Your lordships have held, the Supreme Court has held that in insurance matters, where similar deposit them, and not even deposit, my lord. Now the Supreme Court says, and because of which the Insurance Act and everything is being amended, what the insurance companies used to do. There's a claim of 5 crores. I make a claim of 5 crores. They settle it at 3 crores. And they insist that you file a full and final settlement voucher. Otherwise, we will not pay you 3 crores also. The Supreme Court says this is unconscionable. What you admit is payable must be paid. If he is happy with that payment, the matter ends. If he is not happy, he will litigate. But you cannot put a gun to his head that you must take 1 crore 7 lakhs. If you don't take 1 crore 7 lakhs, I'll not pay you a penny. That is not equitable.
That is not okay.
So that is what this whole suit is about. He wants to file a suit. He wants to drag me to litigation for determination of my right and what is payable to me. I ask myself the question, what stops him from paying me this money in 2022 when he filed the suit? Now we are in 2025. 1 crore 7 lakhs from 2022 till 2025 would have become at least, even at 8% per annum, at least 25% interest would have been earned. This is the whole inequitable action which this is. Wholly inequitable and malafide. I'll show your lordship why. Yes. He's not entitled to any equitable relief. An equitable relief which is all the more discretionary. And this, your lordship has seen, is a commercial dispute. And the Supreme Court has held that in commercial disputes, declaration should not be granted. I'll show you, lordship. Can you give Guwahati first? I have only one copy. I'll come to get this Xerox. I'll trouble your lordship with the others. Give 1976 to SCC 58. 1976 to SCC 58. Well, I take out the judgments. Kindly see, my lord. Kindly come to paragraph 22 of the plaint. How misconceived this suit is, and then they say that give us a decree for the asking without even leading evidence. Kindly come to page 20, paragraph 22, page 11. In the facts and circumstances, the plaintiffs are entitled to a declaration that the defendant number 1 is only entitled to a sum of rupees 89,272, being his share of the balance lying in the capital account of late Dinabandhu Mandal in the firm as on the date of his death, and a sum of rupees 17 lakhs odd as his share on account of, now kindly see, as his share on account of the agreed share of the deceased partner in, kindly sees, fees realized till 30th June 2022 on the basis of bills raised till the death of Dinabandhu Mandal as per clause 17 of the deed of reconstitution dated so and so. Now kindly pause here for a minute. 17,14,501 is on the basis of account of agreed share of the deceased partner in fees realized till 30th June 2022. Who is going to certify what fees have been realized till 30th June 2022? Is this not a matter of evidence, I ask myself? Who's going to certify what is the amount of fees realized?
Yes.
So even if your lordship is satisfied that yes, clause 17 is the repository, nothing else, I cannot get anything beyond clause 17.
Yes.
The application of clause 17 requires determination of amounts, which require evidence. Cannot be granted ipse dixit. Now kindly see, your lordship has been shown 5 decisions of your lordships in trademark matters where your lordships have been pleased to decree because there's no triable issue there, defendant has not come. And in all those decisions, my lord has refrained from awarding damages. Your lordship has not awarded damages in any of, yes, only injunction declaration. So now, my lord, his declaration, and your lordship has seen section 34, declarations are not given when further relief can be sought. So what is the further relief in this case? That he will pay me the money. Without giving that relief, the suit would not have been maintainable first. So overcome that, he says, I will pay you 1 crore 7 lakh. Then I ask myself, who's going to determine 1 crore 7 lakh? Where is the fees? And now kindly see, more interesting. So now today there's no evidence before your lordship. This is a commercial suit. The evidence, if this suit were to go to trial, the evidence would have been according to them, the fees which the firm has earned till June 2022. That is the evidence. Now, what is the evidence even? What is that document is not even filed with the plaint. Kindly see the list of documents with the plaint. Kindly come to page 20. None of this is evidence. But even if this suit were to go to trial, he cannot produce any of the documents because of the bar under the Commercial Courts Act. Kindly see documents relied by the plaintiff, page 20. And your lordship will go through deed of reconstitution, deed, genealogical table, memorandum of settlement, release deed, retirement deed, emails, status report. Then kindly turn over, print out of status report, copy of form TO, the trademark, TO, email, letter, letter, and then kindly see 18, statement of calculation of amount due, annexure R. And this is a document which is now, kindly see page 22, copy of documents annexed with the plaint. No bills have been disclosed, no audited balance sheet, no profit and loss account, nothing. All that has been shown is a copy of statement of calculation amount due, annexure R. Now kindly see annexure R at page 117. This is self-certification. And on the basis of this, a decree is sought without trial. without evidence. This is a statement which has been prepared, my lord. This statement is not evidence. Evidence is the primary documents which would show that in the month of July 2020, the firm has only received 55 lakhs 40,000 and not more.
So you mean to say the corroborative evidence is required to be?
The primary evidence, my lord.
Correct. That's why.
The primary evidence is not there. It is not even there in the suit. And he must explain why it's not annexed with the plaint, because this is a commercial litigation.
Yes.
He must have filed at least the audited balance sheet. Nothing. Now kindly see, in a trademark matter, where the primary evidence is not there and the defendant has not filed a defense, a coordinate bench has been pleased to dismiss the suit. This is very basic, but since so many decisions are shown to your lordship in trademark matters, I thought I must do something, otherwise. Mariko, AIR 2024, Calcutta 158.
$128.
Yes, please. 158. I'm sorry, my lord. 158. May I hand over? Kindly see the second page, my lord. I'm sorry. Kindly see the second page. This suit was also proceeded on the basis of Order 8 Rule 10. All the judgments on Order 8 Rule 10 are noticed, starting from Balraj Taneja, which is the lead judgment, which has not been shown to your lordship. I'll show your lordship this. Now, my lord, kindly come back. I'm sorry, my lord. Kindly come back to paragraph 2 once, please. I showed your lordship the second page. In paragraph 2, your lordship will find there was a deed of assignment.
Yes.
On the basis of which the plaintiff claimed declaration and injunction in a trademark matter.
Yes.
Now, my lord, kindly turn to the last page. All the decisions under Order 8 Rule 10 are noticed, because there also the argument was the defendant has not come and you should dismiss and you should grant the decree. The learned coordinate bench, my lord, refused to grant a decree, saying that the primary document is not even filed along with the plaint. I'm sorry, my lord, I don't have a copy of this.
Yes, I am. Paragraph 16.
Yes. So, suit under an undefended suit, no written statement, fine, commercial cause, primary document not disclosed, on the basis of which the plaintiff was seeking title, the suit is dismissed.
Yes.
So, this is a very basic proposition of law. I need not have troubled your lordship with the decision. But it's not that you walk into court and you get a decree for asking. You have to still establish your case. And here, the case which is sought to be established in the absence of primary document, that is the quantification.
Correct.
So even if your lordship is with him, that this is a declaration which should be granted, A, I say it cannot be granted. The suit is not as framed, does not fall within 34. B, I say it is discretionary. If on both these counts I fail, then comes the third count, whether your lordship should still decree the suit when the main relief, that is the payment of money, can still not be decreed. Then would your lordship, then I ask myself the question, grant a declaratory relief which is of no consequence, because that will not put an end to the list. The list will still continue. Now, apropos this, now, my lord, kindly see Guwahati. Amar copy টা আমার কপিটা তোমাকে বললাম জেরক্স করা কোথায় জেরক্সটা আমার তো অরিজিনাল নিয়ে kindly have, my lord, AIR 1953 Guwahati 162. Get my copy, it is marked. It's here. Watch a mark. Now, my lord, kindly see the first question. 162.
Yes.
This is a suit for declaration. Now, my lord, kindly see, the questions involved in the appeal are whether there was a cause of action for the suit and whether the section 80 notice is there or not. Kindly come to the discussion on this. Kindly come to paragraph 9 onwards. where Specific Relief Act, the earlier version, my lord, before its amendment, before the new act came in 63, when it was, kindly see section 42, the discussion on declaration starts at paragraph 10. The relevant portion of section 42, Specific Relief Act, runs thus. Any person entitled to any legal character or into any right as to any property may institute a suit against any person denying instruction. This is para materia with what we have 34 now, your lordship has seen. Then kindly turn over. It is argued for the plaintiff that he was a person entitled to the property, right of possession and enjoyment of his estates, and the defendant was a person interested in denying his right to such possession because it had already entered the estate in its revenue registers, and by introducing the bill in question was seeking further to take away his right to possess the estate. So, my lord, a bill was made by which the plaintiff's estates would be acquired by the state.
Correct.
The introduction of the bill itself and its passage through the provincial legislature constitutes a valid threat to his rights and casts a cloud upon his title, which he sought to remove by seeking the declaration stated in his plaint, which forms part of the notice under section 80 of the code. The learned counsel in this context has relied upon the memorable dictum of Mukherjee J. in Calcutta. There was a case where a revenue sale had been brought about by deliberate default on the part of the proprietors. Defendant made the purchase at auction sale in concert with the proprietors with a view to annul the encumbrances of the tenure holders, the plaintiff being one of them. It was held on the above facts that before the commencement of the action, there was such hostility on the part of the defendant to the title of the plaintiff as to justify the institution of a suit for declaration that the auction purchaser had not acquired the rights and privileges, so and so. In that view, his lordship observed as thus. It is perfectly true that to entitle a plaintiff to maintain a suit for declaration under section 42 of the Act of 77, he must prove that he has a present existing right and no cause of action accrues to him until there is some threatened, now kindly see, my lord, until there is some threatened infringement or threatened infringement of his right. His right. That is the plaintiff's right. Here, my lord, it is my right to get money. It is his obligation. Kindly see the difference between the two. One is a right and one is an obligation or duty. Plaintiff has no right here. It is the defendant's right to get money. Plaintiff, on the contrary, has an obligation or a duty to pay me.
Correct.
So here the suit will lie for declaration only when there is some threatened infringement or infringement of his right being the plaintiff's right. Correct. In other words, the cloud must be cast before he can ask for its removal. He must allege and prove hostility on the part of the defendant, for the court will move, no court will move on purely speculative grounds. So, my lord, money according to him, what is the suit? Money according to him is payable by him to me on the demise of my father. I raise a dispute saying that no, your calculation is incorrect. What is the bone of contention? That the goodwill of the firm, for that I am entitled to a share. He says, no, goodwill, you're not entitled to a share. In terms of clause 17 of the partnership deed, you're entitled to so much. Now I ask myself this question, my lord, how do these disputes say the firm and me cast any cloud or any question mark on his right? Yes. No right of his being infringed. The right which is being infringed is of mine. It is his liability. He has no right. Yes. He himself admits that I'm liable to pay you, but only this much. I say my right is much more. Yes. So if anybody is entitled to seek a declaration, it is me, not him. Then, my lord, kindly see the next. The learned judge repeated these observations in another decision of his in so and so. I'm not troubling much. I didn't carry the Calcutta decision because they're cited with approval, and this judgment is relied by the Supreme Court, where the facts were almost parallel to the facts in the earlier case. The plaintiff in that case had challenged an ex parte decree for rent and the sale held thereunder of the holding in possession of the plaintiff on the ground that the decree and sale were fraudulent. It was held that the suit was maintainable under section 42 and that a prayer for an injunction to protect the plaintiff's possession was unnecessary. The plaintiff was not bound to wait till he was dispossessed by the auction purchaser, but that he could institute a suit as soon as his title was denied. In the said decision, the learned judge quoted with approval the observations of Seshagiri Iyer in Madras with regard to the scope and effect of 42. I may as well quote the passage here. Kindly see, my lord, the object of declaration. The object of the section is really to perpetuate and strengthen the testimony regarding the title of the plaintiff, so that adverse effects upon it may not weaken it. Pausing here for a minute, I'm sorry, to trouble you. Title of the plaintiff. Correct. Your Lordship will see here, this suit neither involves any title or declaration of the plaintiff. The policy of the legislature is not only to secure to a wronged party possession of the property taken away from him, but also to see that he is allowed to enjoy the property peacefully. In other words, if a cloud is cast upon his title or legal character, he is entitled to seek the aid of the court to dispel that cloud. What we have to consider in this case is whether the decree obtained by D1 against D2 denies the plaintiff's title to the property. It has been said that it is not the function of the court to enunciate, kindly see, my lord, it has been said that it is not the function of the court to enunciate abstract truisms of law. Following the reasoning, it may be argued that as a fraudulent decree can in no way affect the plaintiff's rights, court should not lend itself to the task of declaring what is obviously undisputable. But although the decree may not affect the plaintiff's rights in present time, it is evidence which, if allowed to stand, may result at some future in disturbing the plaintiff's title. I think this is a sufficient grievance which the court should remedy under section 42. So here, my lord, kindly, in the facts of our case, what has the defendant done? What title, character, or property has the defendant cast a cloud on which can compel the plaintiff to run to court and seek this discretion? Now, my lord, I say that you are to pay me 5 crores. He does not pay me, he raises a dispute. The legal remedy which I have is to come to court and file a suit. And there, he will take all these defenses. But he cannot, in a preemptive action like this, he cannot seek a declaration and curtail my legal remedy. Okay. Then, my lord, kindly see, it is impossible to contest the propositions above stated in regard to the scope and object of section 42 of the Specific Relief Act. But it is to be seen whether in the present case there is any such cloud cast upon the plaintiff's title. It must be remembered that the declaration claimed under section 42 lies entirely within the judicial discretion of the court and is to be exercised with caution according to the exigencies of a particular case. There's no exigency here. We have only exchanged correspondence that this much is payable, this much is not payable. Where is the exigency? I ask myself to trouble your lordship with this kind of a suit. Now kindly see next. A party cannot as of right claim such a declaration because such a relief is more in the nature of an equitable relief rather than a legal remedy. It has been repeatedly held that a court should be circumspect as to the declarations it makes, and futile declarations should always be avoided. So even if your lordship is inclined to make a declaration, it will be a declaration in futility because this 1 crore 7 lakh computation cannot be done. Even if I take the plaint to be the gospel truth, it still cannot be done. So one is, my lord, there are 2 limbs of the matter. One is Order 8 Rule 10, whether
judgment can be passed.
Whether a judgment can be passed. So that is one limb of the matter, which I'll come to later. But what was troubling your lordship was, and what I understood on the last day, that very well, Order 8 Rule 10, discretionary, whether I should exercise. But the more important fact is the nature of the suit. Order 8 Rule 10 comes subsequent. First, he has to establish. First, nature has to be decided. Whether a suit of this nature is at all maintainable. And even if maintainable, whether your lordship will be persuaded to grant a decree even at trial. I take my case that high.
That's why in Order 8 Rule 10, with regard to the court has to satisfy with regard to what if the defendant is not appearing or not given the written statement, court has to satisfy with regard to the case which has been made out, need not require further evidence. That is the theory.
That is the theory. Now, in a suit for declaration, whether this suit for declaration as framed at all lies. If it lies, then comes the Order 8 Rule 10 test. I am trying to submit before your lordship that this suit for declaration and the reliefs which have been sought cannot be granted.
Correct. As per your submission, what this court has understood with regard to the section 34, now 34. So declaration, the plaintiff cannot make a ask for the declaration against the defendant instant he paid for.
Grateful.
Correct. And second limb of your submission with regard to the whatever the document they are telling they are entitled for, whether this is the where is the primary document to satisfy that this is the only document.
This is the only amount, or this is the only
Sorry,
fee.
this is the only amount
Yes.
which court can say yes, they are not entitled for
Anything
the further
more.
amount. These are the
So even if clause 17 of the partnership deed which they rely on, even if your lordship holds, and I'm unable to satisfy your lordship that 17 is not applicable, even if your lordship were to hold against me that yes, 17 is applicable, even then, what is the result of 17?
Correct.
Whether
That's why on the last occasion when this court has interpretation the 70 interpretation of the 17 along with the what are the materials on it.
Grateful, man.
The materials on
So and your lordship will not undertake to examine 17 or give a declaration on 17 when it will result in futility. Because because your lordship has seen the section itself says the declaration will not be given unless you ask the other remedy. The final relief is the payment of money. So the final relief cannot be granted by the court if the court should not be granted. It's a waste of judicial time, and futile declaration should always be avoided.
Okay.
Now, my lord, on these lines, may I? It's 76 to SCC 58. Yes. I am troubling your lordship with suits on declaration to show your lordship that whatever little I have been able to find, none of these suits involve a negative declaration that this is a defendant.
That's why I wanted to ask you with regard to the negative declaration. What is the law in the negative declaration?
Well, Lord, I have only been able to find suits where declarations have been sought of plaintiff's right. My learned friends would satisfy your lordship that suits can be sought of defendant's rights also.
Correct.
Because the section doesn't read like that.
As per your submission, as per section 34, the plaintiff has to file the suit with his declaration.
Correct.
His declaration.
He is right.
Now, as per this suit, the plaintiff has prayed for the declaration of the entitlement of the defendant.
Grateful.
Entitlement. Whether the plaintiff can pray for a declaration in the negative form.
Grateful.
Negative.
Not his declaration of
the defendant.
Whether
Whatever.
Yes, whatever. It's the same. Whether he can do that. My reading, my lord, with the greatest of respect, my reading of the section does not provide.
Because that is the amount or that is not in the partnership deed. If in the partnership deed there is negative covenant, then it can be.
Yes. It is not there.
The
amount has, according to that is why I showed you lordship paragraph 22 says it has to be determined on the basis of some data.
Correct.
Data is subjective. It is not liquidated amount. I could have understood that the partnership deed said that on the death of each partner, 5 crores will be paid.
That's why the amount is not specified.
The amount is not specified.
Not specified, and the method which they have calculated, that has to be established.
And even if the method is correct, where is the data to calculate end amount?
That's why that is to be established.
That is to be established. And my lord, all this, the plaintiff is undertaking upon himself the burden of establishing my right. My right, he's taking the burden upon himself to establish and coming to court.
Yes.
That is the whole fallacy in this matter with the greatest of respect. Kindly see 76 to SCC 58. So first they would have to satisfy your lordship that they can seek a declaration of my right, my entitlement, my property, my legal character. The section says plaintiff's legal character. Section doesn't say plaintiff can file a suit for declaration of somebody else's legal character.
That can also be taken into consideration if the defendant has not made any correspondence and not denied for it. If suppose they 1 crore 7 lakh, they made and he was silent.
Yes.
Neither denied, not acceptance. Then some way we can go for the order 8 rule 10 because they have not accepted, they have not denied, not accepted.
Correct.
But here, if they have denied with regard to, but they have not made any claim.
Correct.
So what would be the effect?
And my lord, the denial is his cause of action for coming to court.
Yeah, that's what I'm telling. So what would be effect of?
What if the effect of it? Then can he then seek to establish?
So if they have denied and you have not filed the written statement,
yes,
how far the court can go?
Yes. So my lord, even if then that comes the order 8 rule 10, and my lord, he also argues on admission. Both I will show your lordship, my lord. And just digressing from this declaration, since this is fallen from your lordship, my lord, our court is held, and your lordship has been seen all those decisions in that other matter which I did. Admission is not silence. Admission is positive act and conduct. So by keeping quiet, it cannot be that what you have charged me with is admission.
No, that cannot be. That
That
is
is not the
admission is different.
Admission is
Admission is different.
grateful.
Order 8 Rule 10 is different.
Yes. Now, my lord, yeah, I'm grateful.
No, only I put the question because Order 8 Rule 10. If he has some plaintiff has claimed something from the defendant.
Yes.
But the defendant will not respond for that.
Yes.
And after filing of the suit, after receipt of the written statement,
yes.
defendant don't even not respond.
Grateful.
Then Order 8 Rule 10 can go.
Grateful, my lord. That is where I'm grateful, my lord. That is because the plaintiff proves his claim.
Correct.
Your lordship is satisfied that the plaintiff has proved his claim. Now that
not
is
admission.
Not admission. Yes, grateful, my lord. That is the distinction. There is no Order 8 Rule 10 does not proceed on the basis of admission.
Yes.
It proceeds on the plaintiff proving his case and the defendant not being there. There is no contra evidence. There is no contra pleading, and the court is satisfied that the defendant has not come with any case, and the court is satisfied the plaintiff has been able to establish his case. So plaintiff has to say. Now the very example which your lordship gave, my lord, Order 8 Rule 10, it is a claim of the plaintiff. Plaintiff establishes his claim. Here there is no claim of the plaintiff. That is the whole beauty of this litigation.
Okay,
there is no claim.
It is a good point you are in. Let us see.
There is no claim. Now kindly come to 76 to SCC 58.
Yes.
Here also, my lord, all the judgments on declaration are noticed by the court. This was a case, my lord, where a declaration was sought of a termination of a contract of service. Somebody was in employment, his employment was terminated, declaration was sought. Kindly come to paragraph 22 onwards. I'm just showing your lordship, my lord, what is the law on declaration, as I understand, of course, my lord. Yes. Kindly see 22. As against this position, Mr. Ramamurthy, counsel for the plaintiff, submitted that in Hill versus Parsons, a declaration that the termination was invalid was granted by the court. In that case, however, it was pointed out that the declaration was granted under very special circumstances of that case, where the employee was said to be removed from service almost at the fag end of his career after serving for 35 years, when he was due to retire only 2 years later. In that case, however, Lord Denning laid down that in the absence of any special circumstances, a declaration should not be granted. That is the general law. The exception was this, that he served for 35 years. It is clear that in the instant case, the respondent has worked in the college for only 2 years. In these circumstances, therefore, this case does not appear to be of any assistance to the respondent. The court drew a declaration. Now, my lord, kindly see 23. I'm not troubling your lordship with, because that was on service jurisprudence. Kindly come to 24. A division bench of the Allahabad High Court in Mahant Indra Narayan versus Mahant Ganga Ram Das observed as follows. The second thing to be noted is that the court is giving a declaration to make. I'm sorry,
Court is given a discretion.
I'm so sorry, Malay. Yes, that the court is given a discretion to make the declaration sought, and the plaintiff need not ask for any further relief. The relief being discretionary, no person claim the declaration as a matter of right. So your lordship has seen may. So the court says may is discretionary. Then kindly see 25. This is the Assam decision which I trouble your lordship with. Similarly, in Bharebendra Narayan Bhup was a state of Assam. I'm not reading it because your lordship has already. Kindly see 26. The principles. Apart from these decisions, it would appear that section 20 subsection 1 of the Specific Relief Act clearly codifies this principle and may be extracted as follows. Now this, the court is going beyond section 34 and beyond 42. That what is the Specific Relief Act all about?
Correct.
The jurisdiction to grant specific performance is discretionary, and the court is not bound to grant any such relief merely because it is lawful to do so. But the discretion of the court is not arbitrary, but sound and reasonable, guided by judicial principles and capable of correction by a court of appeal. That is the whole scheme of Specific Relief Act. 34 is nothing but a part of the Specific Relief Act. The whole scheme of Specific Relief Act is discretionary. Now, similarly, section 34 of the Specific Relief Act also gives a discretion to the court to give a declaration of legal character Section 34 runs thus. I'm not troubling your lordship with the section. Kindly come to 27. It seems to us that neither the first additional civil and sessions judge nor the High Court, while decreeing the plaintiff's suit, considered this aspect of the matter, whether this was a fit case in which the discretion should have been exercised in favor of the respondent. So two concurrent decrees, my lord, the Supreme Court is overturning. It is manifestly clear from the authorities discussed above that the relief of declaration and injunction under the provisions of the Specific Relief Act is purely discretionary and the plaintiff cannot claim it as of right. The relief has to be granted by the court according to sound legal principles and ex debito justitiae, in the interest of justice. The court has to administer justice between the parties and cannot convert itself into an instrument of injustice or an engine of oppression. In these circumstances, while exercising its discretionary powers, the court must keep in mind the well-settled principles of justice and fair play and should exercise the discretion only if the ends of justice require it. For justice is not an object which can be administered in vacuum. Kindly see the strong words. Now, Order 8, Rule 10 cannot change the nature of the case. The nature of the case is declaration. These are the principles on which a declaratory relief can be granted. A right is infringed and it is in the interest of justice to grant relief. I ask myself the question, my lord, where is the interest of justice in this? My right, my entitlement is being determined in a suit which is not filed by me, which does not affect him in any manner. He's sitting with this 1 crore. He does not put the 1 crore into court, far to speak of paying me this money. That you're entitled, as per my books of accounts, you're entitled to 1 crore, take your check of 1 crore. Now, if you want more, you go to court and get more.
Okay.
This is the interest of justice which he is now seeking, my lord. This is entirely unjust, this litigation. And, my lord, Specific Relief Act, just to for the sake of completeness, was amended in Section 34 was not touched. The discretion to grant specific relief in cases of immovable property was taken away, but Section 34 was not touched. So this is, my lord, the test which the plaintiff would have to satisfy, that this is a just litigation ex debito justitiae. Next, my lord, on this, kindly have 1993 2 SCC 199. I will trouble your lordship with some decisions in this matter, my lord, because your lordship understands I'm a bit on a back foot. And this litigation is such that there's, given the parties who are involved, it's a very onerous duty which is cast upon me. Kindly see 1993 to SCC 199 now. This was also, my lord, on grant of declaration. Again, a suit on declaration in commercial matters. The Supreme Court, my lord, has frowned upon this kind of litigation in commercial matters. Kindly come to, I'm just showing your lordship the exposition of law on this.
Yeah, how this is the commercial?
It's a commercial matter. It's arising out of disputes of a partnership deed. It's filed in the commercial division. He says this is a Commercial Courts Act now.
2015. So, this is only with regard to the distribution, the share of the deceased who
Correct.
was the partner.
Yes. Well, they have said it's a commercial dispute. May I just show your lordship the plaint once? How they have said that this is a commercial dispute. Kindly come to paragraph. Where have they said it's a commercial dispute? Yes. Kindly come to 28 at page 13.
Partnership agreement comes within the purview of 21C15.
I am sorry, my lord, I did not consider this point.
21C15.
21C15.
Your lordships have passed a judgment interpreting this also.
No, that's not, I don't know. Let me see.
I have not taken this point, but it's a very well, it's a commercial,
No,
because now at this stage, yes, your lordship.
After arguing, then it is come.
There is already a judgment by your lordship
In this?
on this point.
Okay.
My lord, contested. On contest, passed by your lordship.
So, my lord, in a commercial dispute where, my lord, commercial questions are involved, the Supreme Court has held that it is not proper to grant these kind of declaratory reliefs. Kindly see, my lord, 1993 to SCC 199.
Yes.
Of course, the Commercial Courts Act was not there, but it still remains a commercial dispute. So, in a commercial dispute, now, my lord, kindly see paragraph 22.
Yes.
At the last page, 230. Undoubtedly,
Will kindly excuse me for.
undoubtedly, declaration of the rights or status is one of discretion of the court under section 34 of the Act of 63. Equally, the grant or refusal of the relief of declaration and injunction under the provision of that act is discretionary. The plaintiff cannot claim the relief as of right. It has to be granted according to sound principles of law and ex debito justitiae. This is the test, my lord. The court cannot convert itself into an instrument of injustice or vehicle of oppression. While exercising its discretionary power, the court must keep in its mind the well-settled principles of justice and fair play, and the discretion should be exercised keeping in view the ends of justice, since justice is the hallmark and it cannot be administered in vacuum. Can you see the next sentence? Grant of declaration and injunction relating to commercial transactions tend to aid dishonesty and perfidy. Conversely, refusal to grant relief generally encourages candor in business behavior, facilitates free flow of capital, prompt compliance with covenants, sustained growth of commerce, and above all, inculcates respect for the efficacy of judicial adjudication. Before granting or refusing to grant relief of declaration or injunction or both, the court must weigh the pros and cons in each case, consider the facts and circumstances in their proper perspective, and exercise discretion with circumspection to further the ends of justice.
Yes. So exercise discretion with circumstance and further and so yes.
So the appeal was allowed. The High Court had exercised discretion to grant the declaration. The Supreme Court held that on these principles of declaratory relief, the exercise was wrong. The decree was set aside. So, my lord, in commercial transactions of this nature, now, my lord, what is the transaction here? Dispute arising out of a partnership deed. Money is payable to me, admittedly. The heaven is not going to fall if this declaration is refused. I will be the sufferer.
No, they will not.
They will not be.
If the suit is dismissed.
What
would be the effect?
What would be the effect?
So you will be.
I will be with the. If the suit is decreed, my lord,
you will be the sufferer.
I will be the sufferer. I will face questions of limitation.
If the suit is decreed, then you will be the benefit. But your claim, what is your claim, cannot
be adjudicated. So that is why, my lord, the court says, grant of declaration and injunction relating to commercial transactions tend to aid dishonesty and perfidy. A commercial transaction. He has himself said it's a commercial dispute.
Yes.
So what is the pressing need for him first to file the suit? No right or title of his is being infringed. There was no need to file the suit. What is the interest of justice which is being served by the declaration which is sought? Ex debito justitiae, 2 Supreme Courts have said and overturned. This is a larger bench. 93 is a larger bench of 3 judges. They have overturned decrees where courts have exercised discretion and given declarations. 2 decrees overturned there, decree overturned here. The test is it must be in the interest of justice. How is the interest of justice going to be subserved if he gets a declaration which he is seeking? Even if I was there, in this case, I am not there. Order 8, Rule 10 is still staring at me in the face. I am not there before your lordship. I have no right today to put forward my positive case. I can only punch holes in his case. I have to show that his case that does not stand in an Order 8, Rule 10.
Correct.
So, my lord, but the suit itself, the courts have said these kind of declarations should not be granted.
Okay.
Next, my lord. In a suit for declaration, unlike other suits, my lord, the burden of proof never shifts. The burden of proof is always on the plaintiff to prove his case.
Not always.
Yes.
Even ex parte also.
Ex parte also. So, my lord, I am now showing your lordship, my lord.
An ex parte is more dangerous than the contest.
Correct. Because your lordship steps into my shoes, if I can put it that way.
Correct.
The court takes up the case of the defendant.
Court has
to decide. In the absence of the defendant, a greater duty is cast upon the court to satisfy itself that whether the decree which is sought is correct or not. So I have only given one example. I'll take your lordship to the entire plaint to show what are the questions which come up, which can never be decided like this. What is staring at the face is this determination of money. Determination of money on the basis of bills for 3 years, of which there is no cogent evidence. In the example which fell from your lordship, my lord, suit for money lent in advance or suit for price of goods sold and delivered, there is no defendant. But the plaintiff comes up with an Audit 8 Rule 10. Your lordship is satisfied money has gone by bank. There is a money receipt.
The documents.
There is a money receipt. Money has gone by bank. There might be TDS. All these things your lordship will consider and say the plaintiff has proved his case beyond doubt. The defendant does not come and say that he has repaid any money. Therefore, the decree is granted. That is, in a suit for price of goods sold and delivered, there is a purchase order, there is a delivery challan, there is a bill. And your lordship is satisfied that yes, goods sold and delivered is established. There is no proof of payment. Suit is decreed. There can be hundreds of such examples. But in a case here, where the determination of money is on the basis of his bills, of which I have no access, your lordship is not given access, and the amount is disputed from day one, he comes and seeks a declaration. And then he doesn't step into the box to prove that this 1 crore is all that is payable on the basis of these bills. The document is not annexed to the plaint. Okay. The suit should be dismissed. A commercial suit. Now, may I kindly have 2014 to SCC 269.
It's the name.
All these judgments which I am showing your lordship on declaration, your lordship will note a common thread. They are all for declaration of plaintiff's rights. That the last Supreme Court which I showed your lordship on commercial transaction, there was a declaration that the plaintiff is not liable to pay the money. The court said you can't seek that kind of a declaration. He's not liable to pay money. It is for him to come and say how much he is entitled to receive. Now kindly see, Millard, 94. I'm sorry. 2014 to SCC 269. Paragraph A, Millard.
Paragraph?
I'm sorry. Paragraph 1. Wasavi Cooperative Housing Society Limited.
Yes.
Wasavi Cooperative Housing Society Limited, the first respondent herein, instituted suit number so-and-so before the City Civil Court, Hyderabad, seeking a declaration of title over land comprising so much. And recovery of vacant possession from the defendants, the appellants herein, after removal of the structure made therein. In your lordship will see positive. I am the owner, you are the trespasser, you remove your structures. The plaintiff has also sought for an injunction restraining the defendants from interfering with the above mentioned lands under relief. City Civil Court, Virate's judgment dated so-and-so, decreed the suit as prayed for against the appellants, against which the appellants preferred the appeal before the High Court. The High Court also affirmed the judgment of the trial court. But notice that the appellant had made large-scale construction of quarters for the defense account department. Therefore, it would be in the interest of justice that an opportunity be given to the appellants to provide alternative suitable extent of land in lieu of the scheduled suit land, for which 8 months' time was granted, agreed by the same the Union of India and others have filed the present appeal. So, to nature of suit, there is no dispute. 2 suits have granted the declaratory relief along with injunction, mandatory injunction to remove. Now kindly see paragraph 7. And this was in a suit on trial. The plaintiff, in order to establish its claim, examined PWs 1 to 4 and produced these exhibits. On behalf of the defendants, DW1 was examined and exhibits were produced. The primary issue which came up for consideration before the trial court was whether the plaintiff has got ownership and possession over 6 acres and 30 guntas and so and so. On the other hand, the defendants placed considerable reliance on GLR survey so and so of the cantonment, which is part of survey so and so, wherein according to the defendant, the suit land falls. So, my lord, the issue was who has the title. Now, kindly turn to paragraph 11. The above mentioned facts would indicate that the plaintiffs trace their title to the various sale deeds and the oral evidence of the survey officials, and the defendant claims title and possession of the land on the basis of the government land record. The question that falls for consideration is whether the evidence adduced by the plaintiff is sufficient to establish title to the land in question and to give a declaration of title and possession by the civil courts. In paragraph 13, please, my lord. She so-and-so and she so-and-so learned senior counsel appearing for the respondents, who are the plaintiffs, my lord, submitted that the city civil court as well as the high court have correctly appreciated and understood the legal position and correctly discarded the entries made in the government land records, which was a defense case. The learned senior counsel submitted that the correctness and evidentiary value of government land records have to be appreciated in the context of the history of the Secunderabad cantonment. Reference was made to the provisions of the Cantonment Act, etc. Now, kindly see 15. It is strike law. It is strike law that in a suit for declaration of title, the burden always lies on the plaintiff to make out and establish a clear case for granting such a declaration, and the weakness, if any, of the case set up by the defendants would not be a ground to grant relief to the plaintiff. So here on a trial, the court said, you must prove your case, forget the strength of the defense.
Correctly.
So, my lord, even if the defendant is there, he leads evidence, the court says disregard the defendant's evidence. Go only.
The plaintiff has to prove.
Plaintiff has to.
Plaintiff cannot go in the shoes of the defendant.
Grateful. So the High Court, we notice, has taken the view that once the evidence is let in by both the parties, the question of burden of proof pales into insignificance, and the evidence let in by both the parties is required to be appreciated by the court in order to record its findings in respect of each of the issues that may ultimately determine the fate of the suit. The High Court has also proceeded on the basis that initial burden would always be upon the plaintiff to establish its case, but if the evidence is let in by the defendants in support of their case, probabilizes the case set up by the plaintiff, such evidence cannot be ignored and kept out of consideration. This is, my lord, what the High Court did. The law is declared in 15. The High Court did this. Now, my lord, kindly see what the Supreme Court says. At the outset, let us examine the legal position with regard to whom the burden of proof lies in a suit for declaration of title and possession. This court in Moran Mar so-and-so observed that in a suit for declaration, if the plaintiffs are to succeed, they must do so on the strength of their own title. In the other case, the onus to prove title to the property in question was on the plaintiff or plaintiff respondent in a suit for rejectment based on title. It was incumbent on the part of the Court of Appeal first to record a finding on the claim of title to the suit land made on behalf of the plaintiff. The court is bound to inquire or investigate, etc. I'm not troubling your lordship with. Kindly see paragraph 19. The legal position, therefore, is clear that the plaintiff in a suit for declaration of title and possession could succeed only on the strength of its own title, and that could be done only by adducing sufficient evidence to discharge the onus on it, irrespective of the question whether the defendants have proved their case or not. I don't need to prove anything. It is for him to establish that 1 crore is due and payable. We are of the view that even if the title set up by the defendants is found against them, in the absence of establishment of the plaintiff's own title, the plaintiff must be non-suited. So the Union of India, my lord, set up a title on the basis of the government land records. The court said, don't even consider that. First, consider the plaintiff's case, whether any case is made out.
Yes.
And this, my lord, we noticed, paragraph 20, we noticed that the trial court as well as the high courts, rather than examining the question in depth as to whether the plaintiffs have succeeded in establishing their case on the scheduled suit land, went on to examine in depth the weakness of the defendant's title. This is not permissible. 2 decrees, my lord. Set aside, paragraph 24. We reiterate that the plaintiff has to succeed only on the strength of his case and not on the weakness of the case set up by the defendants in a suit for declaration of title and possession. In such circumstances, we are of the view that the plaintiff has not succeeded in establishing his title and possession of the land in question. Appeal is allowed. Judgment of the trial court affirmed by the High Court is set aside. Paragraphs 28 and 29. So, I am better off here. I don't even have to prove anything.
Yes.
He has to prove to the hilt whatever he says. And before your lordship, my lord, there is no evidence.
Okay.
He has not proved a word. Allegations made in the plaint are not evidence. Allegations made in the plaint have to be proved by adducing evidence. Here there is no evidence, and he refuses to lead evidence. Gurbucks.
Yes, then.
Anil Rishi versus yes. Yes, I'm. Yeah, not 1 minute. I'm sorry. Jagdish Prasad. The citation is, my lord. I'm sorry, my lord. There's a Manupatra copy. Kindly have 20. The citation is 2019 6 SCC 82.
Yes.
This was also, my lord, a suit for declaration and injunction of title. Kindly see paragraph 10. Here also, my lord, there were concurrent decrees. The suits were decreed. Kindly see paragraph 10. This is the height test, my lord. I'm just showing your lordship the height test which is set specifically in suits for declaration. The general law is what the Supreme Court has noticed in the previous decision. You
has to prove.
The burden, the owner shifts, keeps on shifting. Okay. He proves a probable case, then I have to rebut that. But in a declaratory suit, it is never the case. I don't have to do anything. I don't have to adduce any evidence.
So the declaration means what? What you want, you have to prove.
Correct. I'm grateful, Mother. That is in one word, your lordship has summed up what the Supreme Court. You must prove what you want.
What you want, you have to prove.
You have to. It is not
you
for the.
Not say, see, the defendant is stated this.
Yes.
That come to my.
Grateful. You must prove what you want. The
defendant. Other case, the court can take the benefit. That's why the cross examination.
Yeah, grateful.
That is the cross examination. Declaration with regard to the document.
Yeah. You have to prove. What the defendant says, in other words, is immaterial. If the defendant says something, good for you. If he doesn't say, also immaterial. Now, Malad, kindly see paragraph 10.
Because I remember this.
Which one, Malad? This?
I remember this before, just 1 or 2 months before my elevation. Justice Arijit Banerjee was hearing my second appeal.
I see.
The same issue was her regarding the declaration of the title.
Yes.
That was,
your lordship would have gone through these.
That was.
So, my lord, yeah, the height test in a suit for declaration, which is, my lord, makes it even more onerous in an Order 8 Rule 10 case. And you see paragraph 10. The impugned judgment of the High Court is the concurrent finding of the High Court and the First Appellate Court. We are conscious that in an appeal under Article 136 of the Constitution, the concurrent findings cannot be interfered with unless warranted by compelling reasons. When the finding of the First Appellate Court and the High Court are shown to be perverse, this court would certainly interfere with the findings of fact recorded by the High Court. So this is the high test that the Supreme Court is reminding itself. Then kindly see paragraph 13, because in this also there were concurrent findings. Paragraph 13. The suit of the respondent plaintiffs is for declaration to their title to the suit lands and the consequential delivery of the suit lands. Having filed the suit for declaration of title, the plaintiffs could succeed in their suit only by adducing sufficient evidence to establish their title. But the plaintiffs have not produced the patta granted to their fathers. PW1 in his deposition stated that the original patta was very old, torn, and the same is not with them. The respondent plaintiffs have produced the report of the revenue inspector, as per which on the application of Vishwanath, an inquiry was made and it was found that the name of the pattedar is Gayadin. Gayadin and Shivnath are shown as leaseholders, and all this evidence is analyzed. So the court finds, Malad, that the primary document, which is the patta, is not produced, and the reasons are given. Now, Malad, kindly see paragraph 58. I'm sorry. Kindly see paragraph 14 plus. And kindly see paragraph 14. In his evidence, PW1 stated that the patta lease was issued in the name of his father. In his written statement, defendant Hanuman Din, kindly see, also admitted that the plaintiff's father were lessees and patta lease was originally granted in their favor during the settlement period for cultivation on the basis of batai crop sharing. So there was an admission even in the written statement. The trial court as well as the first appellate court held that the lease was granted in favor of the respondent's plaintiff at the time of the settlement and they were held to be original lessees. The trial court, while deciding issue 2A, observed that the grant of lease in the name of the plaintiff respondents in the settlement is not rebutted by the appellant defendants. Drawing our attention to the findings of the trial court that patta was granted in favor of the respondents, the learned senior counsel of the plaintiff submitted that this amounts to admission. And in terms of section 58 of the Act, admitted facts need not be proved. This is also a case which they are running before your lordship. Now, my lord, kindly see, and all these decisions are cited. Now, kindly see paragraph 15, where the Supreme Court deals with this argument on admission. Section 58 of the Evidence Act no doubt postulates that the things admitted need not be proved. However, proviso to section 58 of the Evidence Act gives full discretion to the court to require the facts admitted to be proved otherwise than by such admission. When the respondent plaintiffs have filed the suit for declaration of their title, the respondent plaintiffs cannot isolate few sentences in the written statement and take advantage of only those parts of the written statement which are favorable to them. The written statement by the defendant has to be read in toto. It is pertinent to note that in paragraph so-and-so, the appellant defendants avert the facts were in the ownership of Ramraj Singh, but because he was not in a position to cultivate, all these facts are noticed. Kindly come to the next page. The admission of the defendants, about 4 lines from the top, my lord. Yes. The admission of the defendants as to the lease of the plaintiff's father was the lease earlier granted in favor of the forefathers of the defendant. In the light of the pleadings and the oral and documentary evidence adduced by the defendants, notwithstanding the admission in the written statement, the burden lies on the plaintiffs to prove that the patta or lease continues to be there in their favor. They are the holders of the patta and they are in continuous possession of the suit premises. So even if there is an admission, you are seeking a declaration, we will not go only by the admission. Then the court, my lord, analyzes all the evidence which is there and then kindly come to, after analyzing the evidence, the court finds that the, kindly come to paragraph 41 now, my lord. After analyzing all the evidence, because the court undertakes upon itself the burden to analyze whether this is a perverse decree or not, because that is the limitation which they have noted in paragraph 10.
Because the concurrent finding, it is very difficult.
Very difficult. So the court, my lord, the Supreme Court takes upon itself the burden. In a suit for declaration of title and possession, the plaintiff respondents could succeed only on the strength of their own title and not on the weakness of the case of the defendant appellant. The burden is on the plaintiff to establish their title to the suit properties to show that they are entitled for a decree for declaration. The plaintiffs have neither produced the title document, that is the patta lease, which they are relying upon, nor proved their right by adducing any other evidence. As noted above, the revenue entries relied upon them are also held to be not genuine. In any event, revenue entries for few khatunis are not proof of title, but mere statements for revenue purpose. They cannot confer any right or title on the party relying on them for proving their title. Observing that in a suit for declaration, plaintiffs, this I have already shown your lordship, my lord, wasavi. Then paragraph 42, the court notices the evidence which has been analyzed and holds it is incorrect. Paragraph 43, the decree is set aside, the appeal is allowed.
Yes.
So this is the high test, my lord, which the Supreme Court says in a suit for declaration and injunction. Now, my lord, so even in a full suit, which 2 suits I have shown your lordship, declaration, injunction, how the Supreme Court, my lord, lays stress on the evidence of the plaintiff. In this case, there is no evidence of the plaintiff. Now, my lord, kindly have 2006, 5 SCC 558.
Yes.
This was also a suit for declaration.
Agreement per se.
Onek ache, onek.
How many you are having?
My lord, I have quite a few, my lord. I want to, my lord, I have come prepared to argue, place everything, my lord. I will not take time today. 2006, 5 SCC 558. This was also, my lord, a suit for declaration. Can you see paragraph 2? The defendant in the suit is the appellant herein. He is before us aggrieved by a judgment and order dated so-and-so dismissing his revision. There was an agreement for sale. All those facts I'm not troubling your lordship with, my lord. Then the suit was the suit was filed seeking a declaration that the
deed is valid or
deed is valid or not. Kindly come to paragraph 4. The issue framed was whether the alleged sale deed is a valid and genuine document or whether this is forged file. Normally, kindly see paragraph 4. Normally, the initial burden of proving the execution of a document when it is denied must rest upon the person alleging its execution. Here in the present case, the plaintiff has denied the execution of the sale deed. The onus to prove an issue has to be discharged affirmative. It is always difficult to prove the same in negative. When the fact is proved in affirmative or evidence is led to prove the same, onus shifts on the other side to negate the existence of such a fact. Then kindly see paragraph 5. Kindly see the last portion of paragraph 5. I'm not troubling your lordship with what the High Court said. High Court affirmed the trial court's decision. Kindly see what the High Court said. In the impugned judgment, the High Court proceeded on the basis that although generally it is for the plaintiff to prove fraud, undue influence or misrepresentation, when a person is in a fiduciary relationship with another and the latter is in a position of active confidence, the burden of proving the absence of fraud, misrepresentation or undue influence is upon the plaintiff in the dominating position. Now, my lord, kindly see how the Supreme Court analyzes the law on this. The initial burden of proof would be on the plaintiff in view of section 101 of the Evidence Act, which reads as under. This is what your lordship has said, my lord, already remarked. Then kindly come to 7. In terms of the said provision, the burden of proving the fact rests on the party who substantially asserts the affirmative and not on the party who denies it. So he has to establish 1 crore 7 lakh, not on me who's denying it. The said rule may not be universal in its application. There may be an exception thereto. The learned trial court and the High Court proceeded on the basis that the defendant was in a dominating position and there had been a fiduciary relationship between the parties. Appellant in his written statement denied and disputed. So in our case, there is no such exception which is carved out that I am in a dominating position vis-a-vis him. In fact, he is in a dominating position because he is holding my money. Kindly see 8. Pleadings is not evidence. Pleadings is not evidence, far less proof. Issues are raised on the basis of the pleading. The defendant appellant having not admitted or acknowledged the fiduciary relationship between the parties, indisputably, the relationship between the parties itself would be an issue. The suit will fail if both the parties do not adduce any evidence in view of section 102 of the Evidence Act. Thus, ordinarily, the burden of proof would be on the party who asserts the affirmative of the issue, and it rests after evidence is gone into upon the party against whom at the time the question arises, judgment would be given if no further evidence were to be adduced by either side. So, my lord, in our case, coming now to the quantification, there is no evidence by the plaintiff that this quantification is correct. On this ground itself, I am not required to adduce any evidence. The suit must fail. He has failed to prove his case.
Yes.
Then, my lord, in this case also, the distinctions is noticed. Kindly now come to paragraph 14 once.
Yes.
Difficulties which may be faced by a party to the list. Can you come to paragraph 14? Here they said, we have all these difficulties, we cannot prove our exact relationship. In this case, there's no such case that he cannot prove his case. Difficulties which may be faced by a party to the list can never be determinative of the question as to whom upon whom the burden of proof would lie. The learned trial judge therefore posed unto himself a wrong question and arrived at a wrong answer. The High Court, in our considered view, committed a serious error of law in misreading and misinterpreting section 101 of the Evidence Act. With a view to prove forgery or fabrication in a document, possession of the original sale deed by the defendant would not change the legal position. A party in possession of a document can always be directed to produce the same. The plaintiff could have filed an application calling for the said document for the defendant. The defendant could have been directed to produce. And kindly see 15. There is another aspect of the matter which should be borne in mind. A distinction exists between a burden of proof and onus of proof. The right to begin flows follows onus probandi. It assumes importance in the early stages of a case. The question of onus of proof has greater force where the question is which party is to begin. Burden of proof is used in three ways. To indicate the duty of bringing forward evidence in support of a proposition at the beginning or later. To make that of establishing a proposition as against all counter evidence, and an indiscriminate use in which they may mean either or both of the others. The elementary rule in section 101 is inflexible. In terms of 102, the initial onus is always on the plaintiff, and if he discharges that onus and makes out a case which entitles him to a relief, the onus shifts to the defendant to prove these circumstances, if any, which would disentitle to the same. Then kindly see 16. This I have not troubled your lordship with. In so-and-so versus so-and-so 2003 Supreme Court, the law is stated in the following terms. In a suit for recovery of possession based on title, it is for the plaintiff to prove his title and satisfy the court that he in law is entitled to dispossess the defendant from his possession of the suit property and for possession to be restored for him. There is an essential distinction between burden of proof and onus of proof. Burden of proof lies upon a person who has to prove the fact and which never shifts. Onus of proof shifts. Such a shifting of onus is a continuous process in the evaluation of evidence. In a suit for, in our opinion, in a suit for possession based on title, once the plaintiff has been able to create a high degree of probability so as to shift the onus on the defendant, it is for the defendant to discharge his onus. In the absence thereof, the burden of proof lying on the plaintiff shall be held to have been discharged so as to amount to proof for the plaintiff's title. Yes. So here, my lord, he has, in my respectful submission, failed to discharge his burden of proof. In a suit for declaration, burden of proof always remains. Here also, my lord, concurrent decrees was set aside. So all that we have in this suit before us, my lord, are the pleadings and nothing else. Yeah. There is no evidence. And pleadings are not evidence. They are far less proof of the stated case. Now, my lord, your lordship will kindly have whole lot of documents, my lord, have been filed and annexed with the plaint. But no evidence has been tendered. So in my respectful submission, my lord, none of these documents can even be looked into by the court. Because this rule is that filing of documents or bringing of documents on record is not admission of documents in evidence.
Directly admitted.
So even if your lordships have held.
That's why even though at the time of evidence even though document is exhibited, cannot be said that it is proved.
Grateful.
Proving of document is something else, exhibiting of the
document.
That is the law.
That is the law. So here, my lord, none of the documents appended to the plaint. I have shown your lordship they are insufficient to grant the decree which is sought. And this is a commercial suit. So you should have brought everything on record. So the documents as filed are insufficient, number one. Number two, there is no evidence before your lordship because they have not been tendered in evidence. The third stage would have been proved in evidence.
Correct.
So that stage has not even come because nothing has been tendered in evidence.
Because there are three stages: evidence, document, and proof.
Grateful. Here
then
there is
conclusion
none.
Has to come.
Here there is none.
The conclusion has to come. No, here they have 8 and let us see what.
So that is different. So here, your lordship, why I'm saying evidence? Because in all these decisions which I've troubled your lordship with, Supreme Court says that declaration is not to be given as a matter of right, number one. It is to be given only in interest of justice. Number three, now on the evidence part, the declaration of the right which you are seeking has to be proved beyond any doubt. The burden is on you. Yeah. And how do you prove it? By leading evidence. Here we have no evidence.
Okay.
We have only pleadings and we have no evidence. There is, your lordship, while deciding this matter, it is my respectful submission, I humbly beseech your lordship to restrict your lordship only to the consideration of the plaint, which starts from page 1 and ends at page 17 or whatever documents relied upon by the plaintiff at page 23. And I would beseech your lordship to refrain from looking into any of the other documents which are appended. Because as far as my understanding is, although this is a commercial suit, Commercial Courts Act has not done away with the requirement of
evidence, recording of the evidence.
Yes, that has not been done away with. So mere filing is not evidence. Somebody has to step into the box and prove the document. And even if it is marked as an exhibit, what fell from it?
That's why they have made out a case in the earlier order, which this court has stated that this is only the interpretation of the document of the
at that time your lordship was seeing order 7 rule 11.
That's why this clause 17, the clause 17 interpretation, whether they are entitled or not, as per their entitlement, other legal names accepted, he has not accepted, that they have come before this court for declaration that
that is a simple case. Any observation made by your lordship, their reliance on your lordship's order in order 7 rule 11 cannot advance their case. That was a reliance on a dismissal, rejection of plaint, which the prime principle is that everything stated in the plaint is true and correct.
That the plaint has taken into consideration.
True and correct. So in the light of that, your lordship has made.
Now the case is of trial. Judgment. Now the court has to see whether they have proved the matter.
Yes. Now is a case of trial. Now nothing in the plaint is stated is believed to be true.
Now the point is that without the trial, the court can pass a decree.
Correct. And in a suit of declaration.
On the suit of declaration.
The declaration suit gives it a total.
In terms of priori.
Yes. It gives it a totally different character.
Yes.
Now, my lord, on this aspect. 1 second. দাঁড়াও না ভাই। জজ সাহেব বলে দিয়েছেন এবার দরকার এত সব দেখাবার। I'll trouble your lordship with one decision of the Delhi High Court once, my lord, only on this. It's a very decision by Justice Lahoti, as he then was, judge of the Delhi High Court. I find that this decision, my lord, is very instructive in how evidence is adduced in suits, my lord, and how evidence. Principle is what has fallen from your lordship, my lord. Delhi reported judgments, DRJ, volume 34, 1995, 86. 1995, 34, DRJ, page 86. 1995, 34, DRJ, 86. Saying exactly what your lordship has said, kindly only make a note of paragraph 6, 7, 8 of this decision. 6, 7, 8, 10, 13, and 14. Justice Lahoti says exactly what your lordship has said, and he deprecates the practice followed in the Delhi High Court till that date, saying that you may have some rules which you have framed, but the rules cannot change the law of the land. Can you see? Kindly see paragraph 3. Not only the counsel in this case, but also members of the bar usually appearing on the original side and present in the court have stated that it has been a practice of this court not to mark as a document so long as it has not been proved, and endorsing of a document with an exhibit mark is treated as proof of the document. This is what he says is not possible. What your lordship said, an endorsing of a document with an exhibit itself is proof, preempting the right of the party disputing the document to contend at the final hearing that the document was not proved in the manner contemplated by law. So even if it is marked as exhibit, it is not proof. I'm not troubling your lordship will see this. Mere paragraph 8, I am of the firm opinion that mere admission of a document in evidence does not amount to proof. Here, my lord, there is no document which has been received in evidence. And this, my lord, merely filing a document in court but not bringing it on record does not make it evidence. 2013-14 SCC 50. Here your lordship will find in the plaint several documents have been appended, but till the same are admitted in evidence and they are marked as exhibit, they cannot even be considered by court.
That is settled.
Yes, your lordship will only make a note of, I am not troubling your lordship.
Paragraph?
2013-14 SCC 50, paragraph 12 and 13.
Yes.
And to the same is 2007-4 SCC 306, paragraph 4. Very short paragraph. It appears as so. In our view, these documents cannot be looked into since they were not put in evidence and the defendant had no opportunity of replying to these. 2007-4 SCC 306. 4 SCC 306 paragraph 4. These are very melod.
Yes.
And paragraph 12 of that earlier 2013 14 is 12 and 13. Unta not unta paragraph 7.4 paragraph 4. Now let's kindly come back to the plaint ones, where I'll now trouble your lordship with whether any case, had this not been a declaration suit also, this suit is of a different, this suit is a different creature in law. It's a suit for declaration. This is not to be confused with a suit for money lent, and these are not normal suits. These are discretionary suits, and relief is also discretionary. Both. Your lordship finds plaintiff may file. Section the law
with regard to declaration, perpetual injunction, and mandate. These are the very cryptic matters. If you go with the mandatory, so whether it is a mandatory or is a temporary,
yes,
it's very difficult to decide.
Grateful, my lord. And that is why, my lord, section 34, if your lordship just sees once, please with me, my lord. It says plaintiff may file a suit.
Correct,
the discretion is both.
Correct.
You are not required to file a suit. It is in your discretion that you file a suit.
You open your case from the section 34.
Yes.
The plaintiff cannot ask for a declaration against the defendant. He has not asked for any declaration. He asked for the declaration of the defendant.
Defendant's right, title, and
So
interest.
it is your submission.
And my lord, that declaration now it is entirely discretionary whether your lordship will grant it or not. A. So, and B is, my lord, whether it can at all be granted in an order 8 rule 10 scenario where there is no evidence.
That is the only question.
That is the two questions. Now kindly see the plaint ones, my lord.
Yes.
Kindly see paragraph 30 at page 13.
Paragraph 30.
Paragraph 30 at page 13. The cause of action for the present suit.
Yes.
For the first time arose on so-and-so. When the plaintiff at his office within jurisdiction, kindly, my lord, permit me to paraphrase. I'm not talking about jurisdiction here. Cause of action arose when he received the email of 21st March 2022 from the advocate of the defendant number 1. And the cause of action further arose on 14th May when the plaintiff received the subsequent email. Plaintiff threatened to continue to act wrongfully. Plaintiff through emails dated so-and-so, so-and-so, so-and-so replied to the defendant's advocates. The said emails were issued from the office. Now, my lord, what is cause of action? Your lordships have held cause of action is every small infinitesimal fact which the plaintiff must prove in order to get a decree in his favor. This is his cause of action. He has summed up in one paragraph. Thankfully for us, I don't have to take your lordship to the entire. He has summed up his entire cause of action here. For his dispute on account of intellectual property, trademark, etc. is reserved his right in paragraph 31. And then, my lord, 32, your lordship will find, again, he has stated what his cause of action is within jurisdiction or outside jurisdiction.
Yes.
So 30 read with 32, your lordship will find his entire case for coming to court is the exchange of email correspondence between the parties. Now, my lord, not a single email is an exhibit.
So that's why in the cause of action, which as per your submission, the cause of action which they have narrated in the plaint, that is from the document.
No, there's no document.
The document is not exhibited or not proved the court how the court can pass it.
That is a basic. And my lord, even and the court is called upon to grant a discretionary decree.
Okay. Next.
Next, your lordship will see. Yeah. Next, your lordship will kindly have now the test of order 8 rule 10.
Now today Mr. Thakkar is free.
No, my lord, I'm always free.
This court.
But this matter, so I think we should all.
No, my lord. Order 8 rule 10, my lord, the locus classicus seems to be Balraj Taneja. 1999.
around provide
they have said that they have acquired these products from Mishra Steels and BK Enterprises. Now, our contract or dealership, whatever we had with these two entities, that has been terminated. And so right now, even if this is the highest case or the best case that they run, at the moment, whatever it is that they are procuring is not lawful, because the contract or the dealership has been terminated, Your Lordship.
thereafter they say by
Contract or dealer. May I continue, Your Lordship?
Yes.
Yes. Thereafter, they say in paragraph 7, page 5, the defendants are lawfully engaged in the sale of TMT bars from numerous stakeholders across the industry operating in strict compliance. Thereafter, they say in page 8 that they have urged this honorable court to consider the broader market dynamics. And after Your Lordship would kindly take paragraph 11, page 7.
Yes.
Yes. They say that it is pertinent to mention that prior to filing of the present suit, plaintiff has issued a legal notice. So we had issued a legal notice. Thereafter, Your Lordship, there was no reply to that. We also initiated mediation. They did not appear for the mediation. There was a non-starter report that is at page 143 of the injunction application, Your Lordship. Thereafter, kindly takes paragraph 12 and paragraph 13. Lordship, paragraph 12, it is most respectfully submitted, that is my learned friend's case, that the case of the plaintiff is based upon surmises and conjectures, and that the plaintiff has not filed any documentary proof, either by way of trap sales or otherwise, before this honorable court to substantiate their claim of trademark infringement. At present, it is not necessary because we are after affidavits, Your Lordship. Kindly takes paragraph 13. They say that the plaintiff is aware that the respondent has acquired the product from the plaintiff's own dealers and is selling the same product in the market without any changes or impairments. That is not the case that we have pleaded in the injunction application. I shall show. Thereafter, they take recourse to section 33 of the Trademarks Act. They say that the language used in section 33, read with section 34, clearly indicates that if goods are lawfully acquired by a person for the purpose of resale in the market, and these goods have already been placed on the market by the proprietor or with its consent, such acts do not constitute trademark infringement.
So now what would be effect? You have terminated the license.
Yes, Your Lordship.
But still they are selling the product.
Yes, the instruction is that they are continuing to sell.
How they now got? Your dealer has been
terminated. So that is the entire premise of this suit, Your Lordship, that the products that they have acquired is not lawful. We have said so in our injunction application, and
correct.
They are selling the same into the market.
There was a confusion. The
Yes,
court
Your
has not found any prima facie. The
Yes,
court
Your
has not. Now after the receipt of the documents from the defendants,
Yes, Your
so
Lordship.
you find that from where, because they have disclosed where from they have purchasing,
Yes, Your
and you have terminated.
We have terminated because we have also stated that since they have not lawfully acquired the products, so whatever warranty or guarantee which the plaintiff or the petitioner would offer, they are not able to match that standard. So it would actually harm my goodwill and reputation in the market with respect to these marks and with respect to these products. Your Lordship would kindly allow Mr. Ghosh to take.
Your Lordship, I appear for the defendants in this matter.
Yes.
Lordship, Mr. Kumar is actually on his legs today. He's before Bombay High Court, Lordship. And if Lords allow, Mr. Ghosh can make a submission today, and Lords may allow us to make a submission on maybe on the next day.
Okay, let Mr. Ghosh complete. We'll see. No
Please,
Millard, today, Millard, he has no right. Let us, Millard, say, Millard, I have terminated it. Now, with the judgment of Kapil Wadhwa, Millard, which was showed to your Lordship, Millard, that case was also not a case of Millard vacating the injunction in toto. If he, Millard, wishes to deal with the SRMB products manufactured by the plaintiff, which is acquired from some other source, Millard, there should be certain checks and measures, my lord. That lordship has already seen. He has to give a disclaimer that he is not the authorized dealer of
That
the
you have
plaintiff.
submitted on the last.
That, my lord, I have showed from the judgment itself. So, my lord, there cannot be a foolproof, my lord, to give him a go away, my lord, because this is, my lord, squarely covered by the judgment of, my lord, Kapil Wadhwa, my lord, which is, my lord, there is no, if, my lord, there is a lack of disclaimer, my lord, then what is the effect in law? Whether I am entitled to injunction or not entitled to injunction, lordship will kindly take, my lord, the case of, my lord, Christian Lobotin versus Nikunj Bajaj. This is reported in 1460 PTC, volume page 8. This is a judgment of Justice
Manmohan Singh.
Manmohan Singh, my lord. My lord, I had some occasion to appear as his junior, my lord, because he used to do all IP matters all over the country. My lord, kindly have a look at internal page 5. In the case of Titan Industries, has lordship found out? In the case of Titan Industries versus Rajkumar Jewelers, when the identity of a famous personality is used in advertising without permission of the complainant, it is not one who should commercially identity, but the right when, where and how the identity is used should vest in the famous personality. The right to control commercial use of human identity is a right of publicity. Photographs of the plaintiff's product along with the character sweetie such and such. Number 3, Miller, is very important. In case the defendants are selling in grey market, the exception of section 30 subsection 3 of the Trademark Act do not apply to the facts due to the following reasons. A, this is what the Delhi High Court is saying, Miller. Unlawful acquisition. So, Miller, lawful acquisitions are today not lawful. The defendant during the Bridal Asia event held in some misrepresented defendant plaintiff that they have a formal agreement of plaintiff outside India. Now, Miller, kindly Miller, take the website of the defendant alludes to tie up with the boutique with luxury brands from where they source their good. The plaintiff has not entered into any such arrangement or tie up. The plaintiff has relied upon the case of Phillips Morris, Millard, Millard, the lack of disclaimer. In this case, there is no disclaimer or statement being used by the plaintiff to the effect that the goods as sold by them are imported by them and sold by offering after-sales services and warranties which are not under the authority and control of the plaintiff. So, Miller, if he does that, he has to write it on his shop. That corresponding, Miller, has to be there. Difference in advertisement and promotional effects. So, he cannot use my advertisements. Disparities in warranties and after-sale services, misrepresentation in connection with affiliation or economic link. Now, Millard, para 11. The learned counsel of the plaintiff has referred to various paras of the plaint as well as documents placed on record. It appears to the court that the plaintiff has been able to make out a strong prima facie case ex parte ad interim order. In case injunction is not granted, plaintiff will suffer irreparable loss, injury and prejudice. But, Millard, what is important here, Millard, the defendant has to show that he is lawfully acquiring the product, though not from the plaintiff from any lawful source, which is absent in the present case. Nothing in the affidavit has improved from where he is acquiring the product today. So that was the lordship's query, Millard. So, Millard, if Millard he has acquired lawfully, Millard, there has to be a disclaimer that the plaintiff doesn't, Millard, guarantee warranty or Millard services or anything of the mark, Millard, or any defect the plaintiff is not liable thereof. B, Millard, the plaintiff's advertisement cannot be, Millard, looked into at all or advertised at all. He cannot advertise the plaintiff's advertisement for the purpose of selling the plaintiff's goods. And thirdly, Millard, he has to give, and thirdly, Millard, in the event, there is no, Millard, evidence in the affidavit. We are in the affidavit stage that today from where he is acquiring the mark, injunction must follow. This is Christian Lobotin. Now, Millard, kindly have a look at the next judgment. I will just be very short and, Millard, end today, Millard. Kindly have a look at the next. And, Millard, nothing in the, Millard, affidavit in opposition has been disputed. That, Millard, I have already placed, Millard, in quite great detail. Now, Millard, kindly have a look at the next judgment in question, Millard. This is, Millard, a judgment reported of Justice Phillips Morris case, Millard. Millard, 2014 SCC Online, Delhi 1051. If your lordship takes, Millard, just 2 paragraphs, Millard, from Phillips Morris. If your, Millard, submission, I do not, Millard, want, Millard, lordship to go again. Kindly, Millard, takes, Millard, internal page 9, where, Millard, section 29 of the Trademarks Act 1999 And my lord, section 30 limits of registered trademark, section 3 has been quoted.
Yes.
Where the goods bearing a registered trademark are lawfully acquired by the person, the sale of goods in the market.
Where from your reading?
My lord, on the top, page 9, section 29 is quoted, which for infringement we start, because I am the owner of a registered marks. My lord. Miller defense are Miller section 13 limits on effect of registered trademark. He has placed 3 where the goods bearing the registered trademark are lawfully acquired by the person, the sale of the goods in the market or otherwise dealing in those goods by the person or a person claiming under or through them is not infringed by a registered by the reasons of B. Miller, the goods having been put into market under the registered trademark by the proprietor or with his consent. Subsection 3, this is most important. Our case is subsection section 30, subsection 4. Subsection 3 shall not apply where there exists legitimate reasons. I do not have to give any proof. Today I have terminated. I have a legitimate reasons to do. In the ad interim stage, Miller, I was not aware. That's the reason Lordship did not grant me injunction. For the proprietor to oppose further dealings of the goods particular when the conditions of the goods have been changed, impaired or after have been dealt or put in the market. Now, Miller, that is my specific case in the Miller injunction application, not dealt with in Miller the opposition file, Miller. I just indicate the paragraphs. Lordship will kindly now, Miller, the judgment of Kopil Wadhwa has been, Miller, quoted. A division bench judgment thereafter in Kapil Wadhwa versus Samson. Now, Miller, kindly take, Miller, paragraph 36 is the quotation of the division bench. I just place it from here. The division bench concurred with the learned single judge to the extent that in context in section 29, even genuine goods under the trademark which is registered in India, the proprietorship vested in third party in relation to the description of the good would constitute an act of infringement. It is agreed with the learned single judge that section 30 limits on the effects of a registered trademark shall be a good defense to an action in infringement, but also section 30 subse encompasses the exception to rule of infringement provided that the act. But it is disagreed with the learned single judge on the narrow interpretation placed on section 30 subsection 3 of the act, which led the learned judge to hold that the India follows the principle of natural exhaustion. Now, Miller, 37. The division bench observed that the learned single judge has erroneously read lawfully acquired in section 30 subsection 3 to assume the only acquisition with the consent of the proprietor is lawful, but it is to originate from a domestic market itself where it is registered. The division bench internally had there is no law which stipulates goods sold under a trademark can be lawfully only in the country where the mark is registered. In fact, legal proposition is contrary. Lawful acquisition of good would mean that lawful acquisition mark thereof as per law of the country pertaining to sale and purchase of the goods. Now, Miller, if today there is a termination where it is lawful, Miller. Now, Miller, trademark law is not to regulate sale or purchase of good, is to control the use of a registered trademark. Say, for example, there is a food scarcity in the country and the sale of wheat is banned except in the colonizing country. Lawful acquisition of food in that country can only be through the canalization agency. The division bench did not concur with the conclusion of single judge that section is 30 subsection 3b is applicable. The good is put by sale by the registered trademark in the market lawfully or are acquired from domestic market and further sold at the same domestic market. The division bench observed that the market contemplated under section 30 subsection 3 is the international market and not the domestic market. Further, division bench observed under section 30 subsection 4 proprietor has a right to oppose further dealings of the goods in the market under this trademark where there are legitimate reasons to oppose such dealings. The section embraces all legitimate reasons to improve further dealings in the good. It is observed that changing condition and impairment is not only a species of genus of legitimate expectation, which genus embraces other species as well. Now, Millard, Kapil Wadhwa was a case, Millard, that Millard, the goods were Millard imported to India by the importer Millard, who has acquired the goods Millard from the Samsung in Korea. Millard, how this is how it's been explained by the division bench of Delhi in the question. Now, Millard, kindly Millard, straight away come Millard to paragraph 39. Division bench has been explained. So Kapil Wadhwa was misapplied, misinterpreted. Now, Millard, in light of the legal position enunciated by the division bench in Kapil Wadhwa Supra, once the good has been lawfully acquired, the purchaser in accordance with law and sale of purchase in whether in India or any other court, the sale of such goods in India would not infringe the registered trademark in India. Therefore, the importer of the grey market goods person representing him subsequent purchaser would not be liable to infringement of section 29 if he imports subsequent dealing falling under the section of section 30 subsection 3. It's a case of import. The importer defendant has to prove that the impugned mark bearing a particular trademark were placed in the market worldwide by the registered proprietor with the consent thereafter the defendant lawfully acquired therefrom. Now, we'll at paragraph 41. Formula 40. In the present case, unlike Kapil Wadhwa, the plaintiffs are manufacturing Marlboro cigarettes in India which are sold by authorized channels in the local market. The impugned package with the said defendants are selling are not made in India cigarette, but the cigarettes abroad which are not meant for sale in India market. Now, we'll at 41. But in the present case, no defense of section can be raised by the defendant. There is no material whatsoever to indicate the defendants have acquired the impugned goods from the market through legitimate sources. So today the scenario has changed. Yes. The source from which the defendant was acquiring, Millard, those sources have been, Millard, terminated by me, Millard, by terminating the dealership agreement. They do not exist. It appears from the report of the local commissioner that there exists a chain of network for supply of these infringing products, but legitimacy of a source originate is not ascertained. Therefore, in the circumstances of case, protection under section 30 subsection 3 is not available to defendant because they have failed to show that the impugned cigarettes were lawfully acquired by them from the market. Having said that, there is no need to examine whether objection raised by the plaintiff with regard to difference of packaging, quality prescribed, warning labels, etc. constitute legitimate reasons under section 34 of opposing further dealing of the product. Thus, the sale of the impugned cigarettes by the defendant amounts to infringement of the plaintiff's right in a suit for trademark under section 21 read with 26 of the Act. Consequently, plaintiff is entitled to injunctive relief. So this is the case. You have to give a prima facie case. Now, Millard kindly takes the affidavit, Millard, how it has been dealt with. Opposition to the change position. Lordship will take, Millard, my petition, paragraph 21, 22, 23, and 24. And I think change for the that paragraph. This is my specific case. Yes. Paragraph 21 and 22. The respondents have not lawfully acquired the trademark TMT bars from SRMB, etc., etc. Lordship will straight away come. Paragraph 22 will add 8 lines from the top. The petitioner has reasons to believe respondents have changed or impaired the TMT bars manufactured by the petitioner bearing the petitioner's registered trademark and are mixing with the TMT bars impugned with bearing SRMB wind grip X strips of inferior quality, offering and exposing the petitioner's goods in the market and stocking them for sale. Such rights of the petitioner also flows from the trademark of the Trademarks Act. How he has dealt with these paragraphs, Millard, kindly take, Millard, what he has filed is, Millard, an affidavit in opposition. These paragraphs have not been dealt with at all. Para 11, dealing is still paragraph 11. Not dealt with at all. And he has given the screenshots of Mishra Steel. Those are not there, Millard. If your Lordship takes it affidavit in opposition, he has stated paragraph 3. He is obtained it from Agarwal Trading, a partnership. Yes. He is the authorized representative on behalf of defendant number 2, etc., etc. Then, Millard.
Who is the defendant number 2? Agarwal Trading.
Millard, defendant number.
Agarwal Trading is the partnership firm. 1 and 2 are the partners there.
Yes.
Yes.
Now, Millard, kindly take, Millard. Paragraph 13 is, Millard, lecture on, Millard, section 30 subsection 3. And, Millard, he has given, Millard, the consignment note, Millard, from Mishra Steel and BK Associates, page 9 and 10. This is all, Miller.
Yes.
Now, Miller, para 21, if your lordship takes, Miller, this is saying, Miller, there's a specific assertion, Miller, that is not denied. Kindly, Miller, take defendants emphasize that their activities, practices fall within the legal protection provided under provision of section 30 subsection 3 of the Act of the Trademarks 1999, which permits resale of lawfully acquired goods in the original condition. So today, Miller, that connection is, Miller, severed. Since defendant has merely resold the goods on his own to which the plaintiff has earned profit and their trademark right stands extinguished, the goods are being sold without any changes, impairments in the input without an attempt to mislead the customer. So, Miller, I have to only today come raising a legal apprehension or a legitimate apprehension, Miller, being a registered proprietor, that look that you are not dealing with the goods lawfully. In such premise, Miller, I am, Miller, entitled to an order of injunction. Just one English case, Miller, I cite, Miller. This, Miller, if you Anna Miller, I conclude my submission. This is, Miller, the case of Western Judicial Lordship will also, for my satisfaction, Justice Pratibha Singh I had cited Amway. Just Lordship will note the paragraphs. I am not, Miller. Same principles, time and again. Kindly, Miller, have a look at. It's like a book. Justice Pratibha Singh, Miller, as an expert, Miller. Paragraph 333, if your Lordship takes, Miller. I had placed it.
Para
333, conclusions. (336), Lordship will kind. 337, Lordship will kindly take. 337 at page 136. Further, not a single seller has been able to produce. Today, this is the situation. A direct connection with the plaintiffs. This is most important. It's or, not and. Yes. Any consent given by the plaintiffs for sale on e-commerce platform. In all the cases, the sellers are taking enormous efforts to mask their identity and to hide the source of the products. Some of the sellers are all not traceable. The plaintiff face severe jeopardy to their business as selling e-commerce platform is not stopped, poses a threat to right to the carry on the business itself. Now, Miller, kindly take para 339. The principles of Order 39, Rule 1 and 2 are well established. If the defendants are allowed to sell the plaintiff's products during the pendency, this most important, plaintiff's product, during the pendency of the suit, by the time when the suit reaches evidence, the trial is concluded, the judgment is rendered, and if no injunction is granted, defendant may completely erode the business of the plaintiff. There is a reasonable apprehension that direct distribution network of the plaintiff may be affected. This is my case. As per their own policies, sale on commerce of platform unauthorized tampered products is impermissible. The same also completely destroys the goodwill of the plaintiff. The plaintiff consumers may be forced to abandon these products owing to large-scale quality issues of the products through e-commerce platform. Further, the plaintiff may be also called into question at direct government authorities for being violation of the direct selling guidelines and for permitting misrepresentation made as e-commerce platforms are not willing to assume the responsibility. The return and refund policies adopted by the platforms are in complete contradiction to the plaintiff's return refund policy. Since the plaintiff's products are sold directly through the selling channel, the return policies made by the consumer friendly and dilution of these products by itself constitutes impairment and change of condition. This is without impairment and change of condition. Yes. That if you don't give the guarantee, you don't replace the goods, which I'll of course not give, then it's changing the condition itself. Yes. The plaintiff has therefore been established a prima facie case of balance of convenience. Irreparable injury would cause the plaintiff the business of those distributors, successful business employees, directly finally consumed, internally is not granted, and ultimately the injunction was granted. That is, Millard, paragraph, if your lordship takes the last page, Millard, in the follow page 3, para 350. Prayer granted, lordship will say. Is disposed of 350 prayer, Millard. There are other prayers also granted, but injunction is prayer. Para 350.
Yes.
And I end with, my lord, showing, my lord, the UK case, my lord, which I showed in the interim case, my lord. Kindly have a look at, and I end, my lord. This is, my lord, a judgment of, my lord. Chancery Division judgment, my lord. If your lordship takes, my lord, it's, my lord, I had given my lord a copy. The appellants are limited company, para 2, and 2 individual connected with its management, their inclined inter alia offense authorized of trade contrary to section 92(1)(b) and C of the 1994 Act. It's the Supreme Court of United Kingdom's. Lordship will find on the top portion. I'm sorry, my lord. I had the chancery with me. This is Supreme Court of UK. Lordship will straight away come to the finding in question, my lord. My lord, para 5. A significant portion of the remainder goods or however ones where there has been originally unauthorized manufacture of the registered trademark, whether by subcontract, license or otherwise, but the sale has not been authorized by him, they were thus sold bearing the trademark without the consent of the owner of the trademark. The latter types of goods are described by the appellant as goods appearing in the grey market. This is the last portion of paragraph 5.
Yes.
The lordship will kindly take, my lord, section, my lord, para 8 is like, my lord, our, my lord, section 29 subsection 8. And 92(5) is, my lord, akin to or like, my lord, section 30 subsection 3. Now, my lord, para 10, if your lordship takes, without the consent of the proprietor, this is what is being court has been dealing with.
Paragraph?
Paragraph 10. It may be readily agreed by the expression that such signs in section 92(1)(b) refers back to the sign described immediately preceding paragraph A. The difficulty comes when one reads such a sign incorporating the word without consent of the proprietor. Now, my lord, 11. The offences set out in paragraph 92 are as a matter of plain leading, culminating, etc., etc. Lordship will straight away then takes, my lord, paragraph 18 in question, and, my lord, it is said, my lord, this type of action is not permissible. And, my lord, paragraph 18, it's a backdoor venture. My lord, I think, my lord, it's 125 already. I should stop.
Yes, that's all.
Look, that's all, my lord. If lordship, I may end. I just want to place para 18 next day. Lordship will let him take over. Just para 18, that's 125. I missed the clock. I'm very sorry.
Paragraph 18 of?
18 of this judgment, I'll place a backdoor entry. This judgment only I'll place.
Okay. Sensation suffering for the plaintiff, sensation suffering for the defendant. Counsel for the plaintiff has argued at length, but due to paucity of time, hearing could not be completed. This is the matter. When Mr. Kumar will be available?
My Lordship may have it tomorrow if possible. And if not, my Lords, next Friday would be.
Tomorrow fix किया ना कर?
Any day, Lordship, let it be in the
Tomorrow
list.
तो कल fix किया ना?
Let it be in the list. Lordship now has the commercial division.
Let the matter appear day after tomorrow under the same heading.
Grateful. Macho, I'm sorry to keep Lordship.
No.
Obliged.
speak, my lord.
What is the urgency?
Urgency, my lord, is this, my lord, the township containing in MAMC, my lord, contains certain residential accommodations, which, my lord, having not been granted to us, we applied to the judges. Honorable judges granted the direction to the ADDA, Asansol Durgapur Development Authority, to consider our case sympathetically. Thrice they considered, thrice they rejected.
So challenging that order.
Lord,
you challenge that order.
That last order is one-page order, 25th July 2024. I have challenged that in CA number 123, I believe, my lord. Now, my lord, I will be only, my lord, one of the important very aspect is that one secured creditor, State Bank of India, is appearing saying that in company jurisdiction, this matter cannot be made. But I'm saying, my lord, this company, in company jurisdiction itself, the orders were passed because division bench order, then, my lord, Honorable Justice Altabas Kabir passed the order that the township is divided from the main portions of the property, and Lord will kindly allow this matter to.
Next week.
I'm extremely grateful, my lord.
Lordship kindly allows me to mention one matter, my lord, for an innocuous fear of inclusion. My lord, this matter has...
Give whatever the inclusion, give mine.
Okay.
Yes, call the list.
Lord, I am for the official liquidator. Lord, in this matter has come at the instance of the official liquidator because there was a direction for sale of the assets of the company in liquidation. That was conducted through, my lord, Railtel. The representative official liquidator, if your lordship kindly takes the first order, my lord, the order dated 22nd January 2025, page 12.
Page 12 of?
Page 12 of this, my lord, the report.
This is a report?
Yes, yes. This is the report filed by the
soft copy? Who is appearing? Nobody.
My lord, the secured creditors possible. Yeah.
State Bank of India, the secured creditor.
But I'm preparing for Bank of India, my lord, who is also one of the secured creditors.
Yes. Lordship, my instruction.
How many banks are there?
There are, my lord, around 11 banks, my lord.
Lordship, with respect to this, I believe there are three stakeholders. The
Yes.
sale in
Yes.
CA10.
My lord, if your lordships kindly, yes, if your lordships kindly takes the
yes,
page,
which order? Which order?
My lord, that is first order on page, my lord, page 9.
Yes.
So, my lord, the property was valued, reserve price was fixed. This is the order dated 29th August 2024. Subsequent order, my lord, kindly see page 11.
What is the first order? What has got?
Yes.
Direction is also given to leave is granted to the official liquidator to incur necessary expenditure for effecting valuation process.
Yes, yes.
And direction also given to secured creditor being the respondents herein to cooperate and assist the in all manner. So what has happened after this order?
After this order, my lord, kindly turns to page 11. That is the second order, 2nd December 2024, my lord. After the completion of the valuer, the official liquidator paid for, my lord, the leave to, my lord, they publish the sale notice and auction. So
Correct.
that order was passed. My lord, there are two orders, 2nd December and 22nd January 2025.
Correct.
Then subsequent thereto, your lordships kindly see the valuation we have intimated to the State Bank of India, my lord, the lead bank, with regard to the valuation of the properties which were going to be sold.
Yes.
Now, my lord, subsequent thereto, another letter was given to the State Bank of India, the lead bank.
So in terms of the order dated 22nd January 2025, this is the order report you have filed?
No, yes, my lord, but kindly turns to page 18. This is the publication, paper publication with regard to the sale.
18.
Page 18.
Yes.
Annexure C.
Yes.
These are the publications. My lord, in the first lot, left-hand side, your lordships kindly see the reserve price was fixed and 13 crores 38 lakhs.
Correct.
And in the right-hand side, my lord, the reserve price was fixed, my lord. In the bottom, item number 2, 7 crores 30 lakhs 68,000.
Correct.
So that was the, my lord. Now, my lord, your lordships kindly turn to page 8.
Page 8.
Page 8. Because it's my report before your lordships kindly see paragraph 13. My lord, may I place this?
Yes.
Having regards to the facts and circumstances as stated and submitted above, the Honorable Court may be pleased to pass an order for confirmation of sale of assets, lot number 1.
Yes.
My lord, that is
Ferroalloys division.
yes, and my lord, lot number 2. My lord, kindly see the sale price received by the Railtel, rupees 76 crore 78 lakhs. Kindly, my lord, note it down. And the second lot, 52 crore 65 lakhs. Now, my lord, kindly turns to page 18. That is the reserve price which was fixed in the sale notice.
Yes.
In the left hand side,
2
my
crore,
lord,
2 crore 67 and 1 crore 46.
yes. No,
Yes.
my lord, the one is my lord 13 crore 38 lakhs and another is 7
reserve
crore.
price,
Reserve
price and
reserve.
EMD is the 2 crore.
Yes.
Yes.
Yes. So, my lord, the sale was conducted by the Railtel, my lord, more than the, my lord, the reserve price we have received.
Correct.
Now, on the basis of that, my lord, my prayer is, my lord, before that is paragraph 13, my lord, your lordship kindly confirm the sale in favor of, my lord, the Rongta Sons Private Limited, who has made.
So, how many persons have participated?
My lord, if your lordship kindly turns to, that is, my lord, I have given the 44. My lord, kindly turns to page 21. But page 21 to
34.
Yes. Paragraph 21. Paragraph 21. Page 21.
Page
Sorry.
21.
Page 21. My lord,
Auction
kindly say this is the
details.
auction details, my lord. I have given
Correct.
up to page, my lord, up to page 43.
Yes.
And if your lordships kindly see, the sale was come to kindly see the first page, page 21. Bid log details. My lord, kindly see the time. 22.24.
Where from you are getting? Yes,
Another page 21. Last bit, big log details. Big log details. The first line, my lord. 18th March 2025. My lord, the bid was received 22.24.04.
Correct.
So it was continued
So
10 p.m.
It was
And my lord,
last. It was when it was last.
My lord, that is the 18th is the last.
18 the last 11. What is the last time?
Last time, my lord, 22.14, my lord, 10 p.m., my lord.
Okay, 10 p.m. Yes, 22.24.
So
yes.
out of 44 bids, my lord, we have received the highest bid.
Who is the highest bidder? Rungta.
Yes, my lord, kindly see, I have also mentioned that
Rungta is the highest bidder.
Yes, Rungta is the highest bidder, and my lord, I have
Second one is both in both.
In both.
Both.
Yes, my lord, in the first
That is
lot.
the second one.
And my lord, the second one is 52 crores. First one is 76
Where
crores.
is the 52 crore? Second one bidder. Yes.
Yes.
Page 32.
Yes.
Yes. So
And
what
my
is
lord,
the prayer now?
Now prayer is, my lord, let the sale be confirmed in favor of the, my lord, the Rungta Sons Private Limited in respect of the lot 1 and lot 2.
Has they have deposited the EMD?
No, my lord, until and unless, my lord, they have deposited EMD 10%. But the balance amount, my lord, that was in the terms and conditions that subject to confirmation of the sale. So until and unless your lordships confirm the sale, my lord, we have not allowed them to pay the balance amount.
No. Where you have mentioned that 10 because 20% is the EMD.
Yes, 20% is that they have paid.
That's why I'm telling
Yes, that they have
20% is the
yes,
EMD.
Yes, that they have paid.
They have paid.
They have paid.
Yes. Yes.
Question is that there was a joint lenders meet held, and they have we do not stand in the way of the confirmation.
Yes. Who was for the other?
I am for the CFM ARC. Earlier, it was Union Bank of India. The whole loan has been assigned to CFM ARC. I would request the OL to service on the. I'll just provide them the details. So, from the CFM ARC do not have a copy of the applications. None of the application are with them, and they.
So earlier you are not appeared.
No, they have not appeared, my lords. This is the first time that we are appearing. CFM ARC. Yes. The whole lot of corporate Ispat is assigned to CFM ARC.
Whole lot of?
The loan that was taken by the corporate debtors has been assigned to CFM.
So what is the total loan?
Bank of India.
What is the total loan is with you? What is the loan amount as on date?
Lordship, there are several properties involved. This is with respect to.
But in respect of these two lots, my lord, only three securities.
Yes,
Who are the three securities?
Lord, SBI, State Bank of India, IFCI and Indian Bank. These are the three. In respect,
Indian Bank, State
IFCI
Bank,
and SBI.
SBI.
These are the three.
So they are not connected with regard to this property.
Not even I am also not.
You are not also not connected. So do one thing, you submit the report to these three creditors.
Very good.
Serve the copy. Let you come on, take the note of all this.
My question is that there is no objection.
But other two,
But they are not the securities only in respect of both the
other two in this.
Oh, I say yes.
You serve that.
So I have to give the notice.
Give the notice to them
Very good.
by forwarding this copy. If they will come after receipt of the notice, they will.
Joint lenders minutes, if I may submit that.
Yes, because they are the lead banks.
Submit it. I've just instructed to print it. Lordship will kindly keep a short passover. I'll just file that in that. Not like.
Okay, short passover. Passover. Next.
Lordship, item number 2 and 3 are the same matters. 2 is a application on part of the official liquidator, Your Lordship. This is an application seeking dissolution, Your Lordship. And Your Lordship, we can file the report, Your Lordship, if Your Lordship pleases.
We are seized on official liquidator shall cause publication of the advertisement in the circulated English daily Bangla newspaper.
7.
Have you circulated?
Lordship, that is, report has not yet been filed, Your Lordship. The advertisement has been done for the point of dissolution, Your Lordship. And CS7 is their application, Your Lordship, where we have the direction upon the to file opposition, Your Lordship, may be permitted to file the affidavit in opposition and to serve the copy upon my learned friend here and now, Your Lordship.
So what about the CS6?
CS6, Your Lordship, we have here we have sought for dissolution of the company, Your Lordship. The fund position, we have indicated, the present fund position, we have already indicated in the opposition, Your Lordship. So to that effect, Your Lordship, we can file
Opposition you filed?
Lordship, in CS7 we have filed. CS7 is their application and CS6 is our application.
So CS7 you filed the reply? I filed the reply.
No, I'll go through it. Today I've just received.
Today you received. So CS7 you will file the reply.
Time,
Lordship, both can come together.
So what about the CS6?
Lordship, CS6, Your Lordship, there's an application for dissolution. So, Your Lordship, so to that effect, Your Lordship, prayer 9 may be allowed to file accounts so that.
Because in any event, that will have a
Let
bearing
both
on
come
CS7.
together.
Well, Lordship, let both the matters come together, Your Lordship.
Meantime, they can file the accounts if Your Lordship so wants.
But subject to
let the
be completed. We will come up with
Let it be completed first. You are for the official liquidator?
I am for the official liquidator, Your Lordship.
And you are for the Mr.
Lord, I am for some of the members of the company, Lord, applicant.
So appearing for the applicant. So appearing for the official liquidator. Full stop. The official liquidator has filed affidavit in opposition in connection with CS6 of 20.
CS7.
CS7 of 20. CS7.
Lordship, CS7 is their application. To that effect, we have filed the
CS7 affidavit.
That is basically not for distribution of the surplus.
Affidavit in opposition, CS6 here.
CS7.
CS6 has been filed by them.
Application.
CS7 has been filed by
Okay.
us. Against that, not there.
And copy has been served here and now, Your Lordship.
Has filed the affidavit in opposition in connection with CS7 of 2024. After serving the copy to the applicant, let the same be kept with the record. Counsel for the applicant, prays for time to file affidavit in reply. Let affidavit in reply be filed within a week. Within a week. Let CS6 of 2024 and CS7 2024 be placed on tenth or 17th?
17th.
17th.
Your Lordship.
17th.
Grateful, Your Lordship.
Or 17th Thursday. No, just a minute. So we are on 16.
16.
Next.
But I am for the official liquidator. This is an application for dissolution of the company in liquidation. But the payments of the creditors have been made. Nothing remains, only 2 lakhs of rupees is remaining. My lord, if your lordships kindly see the affidavit, paragraph 6.
Affidavit of
Affidavit
CA
in
25.
support of the, yes, in support of the, my lord, the summons.
CA 25.
My lord, yes, CA 20.
CA 25.
CA 20.
Paragraph.
Paragraph, my lord, paragraph 7, page 5. Paragraph 8 is the total amount lying in the hands of the official liquidator. And my lord, paragraph 9.
The present fund position is the company is 2,68,000.
2,68,000. My lord, it is required to be sent to the Reserve Bank of India.
So it is in your hand.
Yes, in my hands. Now in my hands. So my lord, my first prayer, my lord, your lordship kindly allow the first prayer, prayer B. That would be fair. The Honorable Court may be pleased to pass an order directing the office of this official liquidator to issue advertisement in newspapers, English, Bengali, and Hindi, and official website for inviting objections, if any. So entire proceedings has been concluded by the official liquidator in persons of the Companies Act 1956 and the rules made thereunder.
Correct.
Now, if anything is remaining, my lord, if anybody has got any objection, my lord, he should be at liberty to my lord, raise an objection. So that is the reason for which I have made a prayer B. At this juncture, I am asking for prayer B. So if there is no, my lord, the objection,
If nobody will come, then
then resolution can be passed, my lord. So,
Consensus appearing for the official liquidator. Consider the submission made by the counsel for the petition and peruse the pleading. This court find that at this stage, prayer B of the judge's summons is allowed. Prayer B of the application is allowed.
let it be returnable on my lord, at least a month.
Be allowed.
4 weeks after 4 weeks,
The
my lord.
official liquidator is directed to submit the report within 4 weeks or 3 weeks.
Within 4 weeks.
Within
paper
4 weeks.
publication, so that is
Within 4 weeks. List the matter on 7th May.
I am deeply oppressed.
Item number 5 is my application, my lord.
The council has not come as today, I think.
Yes.
Lordship may kindly see the last order of Lordship of 3rd March.
Lordship, I am the official liquidator. My counsel has not come today. So kindly grant next week.
Time.
Yes, sir. Lordship. Because he has not come.
I am 9th, I am not there.
Actually, earlier,
What has happened, my lord, I'll just indicate, my lord, what has happened. This company has gone into liquidation way back in 1980s. Its property has been auction sold. I have purchased that property for a valuable consideration from the official liquidator itself. Now, some of the creditors were not satisfied. They were
with regard to the valuation.
Not regarding the valuation, regarding their settlement of the claim.
Okay.
So therefore, they were pursuing their remedies here. Now, Lordship, the coordinate bench had passed an order directing that the entire matter should go to NCLT. The creditor challenged that before the Honorable Division Bench. I also implemented myself in the Division Bench, since even though the official liquidator handed up the property, but because of the pendency, the deed was not registered in my favor. I was already working there. My factory is operational. About 1,000+ people are working there. It's in Midnapur, about 24 acres of land. Now, Honorable Division Bench directed that since the entire proceedings are effectively over, the single bench, Lordship's coordinate bench, should hear it out. At that stage, I took out this application of CA 68. In that, my learned friend sought time to file a report in the form of affidavit. I actually do not understand what report they will file, because everything is on record.
CA 68.
CA 68 of 2024.
Achha, next matter. Okay, yes. Then. So on 67 also, Report shall be filed within 2 weeks. Have you filed the
Lordship,
67?
today I am filing the report, sir.
So they take
In
copy-
which matter?
Copy will-
In which matter? 67?
Yes, 68.
Where is the 67? Where is the report in 67? In terms of the order dated 3rd March?
So matters same, sir. So report I have filed the reports.
That is in 68. So you want that this 68 report is to be treated as the report in the 67 also?
Yes.
A copy may be given so that I can use my
No,
reply.
if you will say, then I will record that the report submitted by you in CS 68 shall be.
CS 67 was also my application before the Honorable Division Bench.
Lordship, keep on record, sir. Lordship, this.
No, if you say 68 will be relied in the 67 and you will not file a separate report in 67, then I will record an order. So the report filed by the official liquidator in 68 shall be treated as a report in 67 also.
Lordship, copy has already been served to you, Lordship. Yes.
You give one copy. Give one
Okay, I will
copy.
give- okay. I can give you. Okay, I will give you again. Again, I will give.
So and so appearing for the official liquidator. So and so appearing for the applicant. Official liquidator has filed a report in connection with CA number 68 of 2024. Full stop. The official liquidator submits that so and so official liquidator is present in person. You are official liquidator in person, na?
Yes, sir.
In person, na? Full stop. And the office submits that the report submitted in CA 68 of 2024 be also be treated as a report in CS 67 of 2023. Full stop. The official liquidator is directed to serve the copy of the report to the learned counsel for the applicant in course of the day. Today will serve.
Yes, sir.
In course of the day. Full stop. Counsel and the official liquidator prays for time. In view of the above, let the matter appear on.
I may be given a
You will file report.
a reply
Exception.
exception if it is if required, if any.
The counsel for the applicant submitted. If required, he may be granted time to file exception if any required. In view of the above, the applicant is liberty to take exception to the report, if any, within 2 weeks from date. Will establish the matter on 23rd of April 20.
I am obliged. I am much obliged.
Next,
Same, Lordship.
that is order in 5 and 6 both. 5 and 6 combined. Yes.
Lordship, 7 is same.
Same.
Kindly keep- Yes.
No, not 7. This is 7 is different. 69. CS 69.
Serial number 7.
Serial number.
Tata Construction.
I am not there.
Who is appearing for the applicant? You file the report. Is there any direction?
No.
There's no order. There's no order in this matter. The first time. Huh? Oh, naya file. The first time. Eh? Yes.
Kindly keep on, Lordship, 23rd.
23rd. As per the prayer made by the official liquidator, the case is adjourned. Let the matter appear on 23rd April.
I am for the official liquidator.
You are appearing for?
Official liquidator.
Yes.
Lordship, the application is taken out on behalf of the official liquidator.
The application is filed by the official liquidator?
Lordship.
Yes. What is your prayer?
Lordship, prayer for leave for granting official liquidator to serve a copy to the application to the Tahsildar of Bhilwara, Tahsil Mandal, village Vadu, district Bhilwara, Rajasthan. So,
Why? The property
situated at Bhilwara, district Bhilwara. So this is the I am praying for only prayer number 1A, Lordship.
So suffering for the official liquidator. Full stop. Prayer A at this stage, prayer A is granted.
15 days
is allowed. Full stop. The petitioner is directed. What? Why for 15 days?
To serve the copy to Rajasthan Lordship.
15 days.
Lordship, 15 days, Lordship.
By post. How we will serve?
4 weeks time because they send by post then.
Yeah, prayer is granted. The official liquidator is directed to serve the copy of this application to the Tehsildar, Mandal Tehsil, MOND, Mandal Tehsil, Village Bhadu, District Bhilwara, Rajasthan, 311403 within 4 weeks from date.
Lordship.
List the matter on 7th May.
Lord, 9 and 10, I appear for the contributory, my lord, who has paid off and the company has come up of the winding up. Now, my lord, this order, my lord, nothing has been served on us, but we've come to know this is a recalling of a recalling application.
Who filed this?
This is by a third party who was in possession of the property by virtue of a suit, my lord, a fraudulent suit filed at Alipur. Now, these have been dismissed. Now, the recalling that he is seeking for is a recalling of a recalling order of Justice, my lord, Ravi Kapoor, where, my lord, the matter is part heard. So, my lord, I don't think Lordship will be able to take up this
matter.
Part heard matter.
Who is for the? Nobody.
I'm for the official liquidator. I believe they should also know. Application was dismissed.
Huh?
We are all respondents.
But their application was
They were the twice. Twice it has been dismissed. This is a recalling of a recalling.
And today they are also not present.
And it's as it is, my lord, it would be before Justice Kapoor, my lord. It's a recalling modification.
Is there any order?
Yes, my lord. We can give a copy of the order, my lord.
November
You have a copy of the order?
November, kindly turns to
Page 7, my lord, kindly sees. 12th August 2024.
Being order dated 20 division bench direct disposal application. Despite of the representing country,
one application is condonation of delay and one application is recalling of the order.
Stand dismissed. So this is application for recalling of this order.
And one is, my lord, for recalling of a recalling. That was also a recalling which was dismissed.
Application recalling of the order dated remain represented.
And the suit was dismissed.
So, my lord, this has to be in any event. It has to go to the proper, my lord, determination, my lord, where it is part heard, my lord.
Dismiss করে দিন।
হ্যাঁ, সেটা তো এখানে তো maintainable নয়. Obviously, it has to be dismissed.
None appears on behalf of the applicant. So and so appearing for the official liquidator. And so and so appearing for the respondents.
We are all for the respondents, my lord. We'll give our names.
We are for the respondent contributory.
And
we are for the
respondent. So and so appearing for the respondent contributory. And so and so appearing for the respondent WPDC.
One of the secured creditors.
Who has been paid off.
Who has been paid off.
Respondent number 2. Full stop. It is fine from the record, the applicant has filed the present application for applications for condonation of delay as well as for recalling of the order dated 12th August 2024. The counsel for the respondent submit that the matter is parted before the Honorable Justice Ravi Kishan Kapoor, and as such, in view of the above, the matter is released from the list of this court with the liberty to the applicant or the parties to mention before the appropriate court.
For the petitioner, we should not, for the petitioner.
To the applicant.
Yes, otherwise it would be on me.
To mention before the appropriate court.
Grateful, my deeply. Both the matters, my lord, same order.
9 and 10.
9 and 10. Grateful.
Separate.
Lordship, item number 11 and 12. Regarding item number 11, your Lordship, I'm for the official liquidator. Item number 11, this application has been taken out by the joint officers, Your Lordship. 2 officers were appointed, Your Lordship, pursuant to the direction.
Special officer.
Special officers, Your Lordship.
Correct.
But this, the copies has neither been served upon the official liquidator, neither they are appearing in person, Your Lordship, despite the direction, Your Lordship. That is the position as of now.
Last occasion also they were not present.
For 2-3 occasions they were not present, Your Lordship.
So I am dismissing it. What can be done? What is the prayer?
Lordship, that application they have not served. Lordship,
Direction?
they were a person to the direction of the Honorable Court, Your Lordship. There was some obligation upon the joint special officers regarding the properties, because they are collecting some of the funds of the properties of the
They file an application for their discharge.
for discharge. But if they discharge, somebody else is required.
But first, they have to submit the report. What is the report?
Lordship.
If the report is conclusive, it is okay. If it is not conclusive, then other special officers has to be appointed. But nobody is there. What can be done?
Lordship, it can be dismissed, or we can serve notice upon them, or
Who will serve the notice?
Lordship, as your Lordship pleases.
They are the applicant.
Lordship, that is admitted position. Because pursuant to the direction of 17th August 2023, they were appointed.
So and so appearing for the official liquidator.
Lordship, in this matter, Lordship, may I permit to mention one thing, Lordship? There is another application being named as
You are appearing
58
for
of
whom,
2000.
madam?
I am appearing for Ministry of Defence, Lordship, which is not a party of this application, but is a party of CA 58 of 21, which is connected with this matter, Lordship.
Appearing in the list, your Lordship.
Okay. No.
Lordship, in the report of official liquidator, there was an arbitrate amount which was required to pay in favor of the Ministry of Defence, Lordship. But till date, that has
in which
order.
application you are mentioning, madam? Which application number?
Application number 58 of 2021, Lordship.
Now, that is not there in the list.
That is not in the list. This is 60.
Yes, Lordship. Yes, Lordship. Therefore, I am mentioning to tag that matter in this. Lordship.
Mentioning, you have to mention the matter before.
We have mentioned it several times. It was accepted by your Lordship, but it never came on list, Lordship.
Okay, I am dismissing it. On the next day, you mention it, and the matter will be taken on 58 will be taken on record. So 58.
Oblige, your Lordship.
Note of it. Next time, the 58 will be listed. So appearing for the official liquidator. None appears on behalf of the applicant / joint special officers. This could find that the matter was taken up for hearing on 26th of February 2025. On the said date also, none appears on behalf of the special officer. None of a special officer in this court has directed the special officer shall be present on the returnable date. Full stop. It is fine from the record. The joint special officers have filed CS 60 of 2023, praying for their discharge, but none has come forward either to
Do we have to collect the rent from the joint recipients also?
make prayer for accommodation or to move the application. In view of the above, this court finds that the joint special officers who have filed the present application are not interested to proceed with this application. Accordingly, CS 60 of 2023 is dismissed for default.
Lordship, in this regard, one more submission I want to make, your Lordship. The role of the special officer in this joint special officers in this matter was that they were collecting the rent of a particular property. Now, if this application is dismissed, your Lordship, the rent may be directed to deposit at the office or the concerned account of the
or otherwise I will do how the notice. Can you serve the notice? Send the notice.
Lordship, I will try my level best, your Lordship. Whether they are come up with the court or not, that is also I'm not sure. But the point is, your Lordship, if direction is given, we can give notice for at least depositing the rent.
None appears on behalf of the special so and so appearing for the official liquidator. None appears on behalf of the joint special officers. List of there's a specific direction has been passed by this court dated 26th of February 2025 by directing the joint special officer to be present before this court, but none has appeared on behalf of the but the joint special officer are not present before this court. In view of the above, for the interest of justice, the official liquidator is requested to inform the next date of hearing to the joint special officer, and the joint special officer directed to appear before this court on the next date fix.
Lordship, we will try our level best if it can be.
Please the matter on
Lordship,
9th April.
Lordship, CA 64, Your Lordship. 64, Your Lordship. Here, Your Lordship, we have filed the compliance report because this application was a behest of one of the creditors and the payment has already been made. This is a property lying and situated at Behala. It's a Behala unit, Your Lordship. So accordingly, we have filed the compliance report also, Your Lordship, that has been recorded on 26th February 2025. So this application can be disposed of because it is there.
Who is for the applicant?
The applicant is not present today, Your Lordship.
Order sheet ache ki?
And apart from this, Your Lordship, the auditor's report shall be filed under section 221. This requires to be modified, Your Lordship, because some claims are still unpaid, Your Lordship. So therefore,
As per the order dated 26th of February, certified copy of the audited report shall be filed under section 281 of the company's court rules.
Lordship, dissolution proceeding at this juncture, it is not possible, Your Lordship, but the compliance report, since we have filed and in respect to the relief that has been sought for, so therefore this application can be disposed.
But nobody is there.
I can dismiss Your Lordship in that effect.
First day, I don't want to dismiss it. So and so appearing for the special officer liquidator. Officer liquidator has filed the report. Let the same be kept with the record. Full stop. For the interest of justice, the case is adjourned. Let the matter appear on 16th April 2025. It is made clear that on the date fixed, if none appears on behalf of the applicant, from appropriate order will be passed. Next.
Lordship, regarding item number 13, Your Lordship, here, Your Lordship, we are seeking for the sale of the property, Your Lordship, and let that advertisement be made, Your Lordship. But
You file the report.
Lordship, report we have not filed. This application, there was a direction also. CA10 and CA12. CA12 has been also been filed at our behest, Your Lordship, that both the applications may come up together, Your Lordship. Report has already been filed in CA10. Yes, Your Lordship.
CA10 and CA12.
CA12, let both the matters come together, Your Lordship.
So today is fixed for only CA10.
CA10.
CA12 is not there.
12 is not in the list.
Let the CA12 come together. So and so appearing for the official liquidator. None appears on behalf of the applicant. Full stop. The official liquidator has filed joint report in CA10 and CA12, CA10 of 2019 and CA12 of 2021. But it is found that the record of CA12 is not placed before this court. Accordingly, the department is directed to place the record of CA10 CA12 of 2021 along with CA10 of 2019 on the next date fix. List the matter on 16th.
Grateful, Your Lordship.
Pass your motor call.
Lordship, this is the minutes. And
Password.
But if your lordships kindly turns to the report, page number 47, where my lord the consent has also been given, that is through email. Page 47 of the report. Yes. State Bank of India, my lord. Because our letter was page 45 and page 47, my lord, kindly see with reference to your letter dated so and so advice that about the successful auction of both the plants amounting to rupees so and so. In this connection, we advise that a joint lender meeting with IFCI and Indian Bank has been conducted on 21st March 2025. In the said meeting, it has been decided that lenders do not raise any objection of the successful bids of the said plants and give our consent to office liquidator to kindly process further course of action and move to the Honorable Court for confirmation of the sale in the next date of hearing. My lord, that was their intimation.
The minutes has been handed over to
yes.
your lordship. Second page.
What is the property?
My lord, that is that property mentioned in, my lord, the sale notice, my lord. Kindly see.
Factory?
Yes.
Factory.
Factory.
Ferroalloy.
My lord, page
Ferroalloy
18, my
is
lord.
going to be
Page
sale?
18. Page 18, my lord, this publication.
Ferroalloy division.
Yes.
There are two
And
divisions.
another
There are
is
two
captive
divisions.
power plant.
Yes.
Three properties, two properties
Two
sold
properties going to be
together and one property sold separately.
So,
There are three properties in total.
where is the prayer? What
So,
is
my
the
lord,
prayer?
my prayer is page 9, my lord.
Page 9 of this?
Page 9 of
9
the,
of
sorry,
CA?
my lord, page 8 of the report.
8 of the report.
Yes, my lord. My lord, twofold prayers. First of all, my lord, your lordships kindly confirm the sale in respect of the lot number 1 and lot number 2 in favor of, my lord, the highest bidder, Rungta Sons Private Limited. That is first prayer. And second prayer, my lord, leave may be granted to the official liquidator to return and release the EMDs put by the H2 and, my lord, H3. These are the two prayers, my lord, I have.
Yes. And what is the prayer in the main application?
Their application, CA10.
Oh, yes, my lord. My lord, that is the prayer. My lord, if your lordships kindly takes the judge's summons for direction. First prayer A, leave may be granted to the applicant to serve the copies
That is
of
so.
the
That is so.
been allowed.
One is so.
A and E initially over, then subsequently, my lord, the prayer B, C, and D was passed.
Lordship, B, only the last line, subject to confirmation of the
Yes.
Honorable Court, is the prayer I believe my
Yes,
learned
yes,
senior
yes,
friend is seeking
yes.
now.
B.
Yes, B last line, yes,
Last line.
confirmation.
Confirmation.
Yes.
Such auction may be conducted as lot 1 and 2 upon considering the valuation report being submitted to court appointed valuation subject to confirm. Yes.
But if your lordships kindly turns to page 11 and 12, then your lordships, it will be made clear. But page 11 was first prayer was passed, my lord, A and E, and second, my lord, page 12, my lord, the order dated 22nd January. Prayer B, C, and D of the master direction are also allowed today. Leave be granted to the official liquidator to conduct the auction through Railtel Corporation. A report with regard to had to be submitted. And my lord, my learned friend was rightly said that prayer B subject to confirmation.
Yeah, last line. Last line.
Yes, last line.
So that is a prayer in the paragraph 30.
Yes, madam.
So we have held the joint meeting, so the non-necessity for service of the copy. Sense offering for the official liquidator. Since you are appearing for the State Bank of
State
India.
Bank of India.
Sense offering for the State Bank of India. Sense offering for the IFCI. Nobody is.
He is representing both the, my lord.
Actually, this is the lead bank.
Lead bank.
And sense offering for the Indian Bank. Nobody is there. So can it be taken or the notice is to be issued?
Lordship, it can be taken because Lordship will kindly note that they have all participated in the minutes meeting.
Sense offering for the official liquidator. Sense offering for the State Bank of India. None appears on behalf of the IFCI Limited and Indian Bank. Full stop. The official liquidator has submitted a report containing 47 pages, wherein it reveals that e-auction sale notice was published in the daily newspaper on 18th of February 2025. By fixing the reserve price of ferroalloys division / unit and a piece of land, a sum of rupees 13,38,00,000,000, and EMD of rupees 2,67,60,000,000, and captive plant and captive power plant of reserve price of rupees 7,30,68, 7,30,68,000,000,
68.
and EMD of rupees 1,46.
Yes, 46.
46,18.
18.
Put the you have
600.
put the total seal on the figures.
Yes.
000.
My lord, 73068,000.
73068.
000.
Correct.
And my lord, the first one is 1338.
Then person is on, and EMD is 1,46.
Yes, 146, 13,600.
13,600. Okay. 13,600. In after publication of the notice, altogether 140. How many persons have participated?
My lord, 44. My instruction is 44 participants.
Total 44.
Yes.
Total 44 firms, persons have participated in this tender process. And after opening of the said tender, it was found that
my lord, page 21, my lord, it is mentioned, my lord, lot number 1, number of bidders 23, and my lord, the lot number 2.
After opening of this
page 30
notice, altogether 12.
Yes.
Bid 1 is the 12, na?
No, bid 1, my lord, is the 23.
Where
Page
it is?
21, my lord.
Page 21.
Number of bidders. Lot 1.
Acha.
Number of bidders 23. Number of bids 343. And my lord, page 32.
Yes.
That is
26 and 420.
Yes.
क्या बोला? The notice. नहीं, after publication of the e-auction notice for the lot 1, 23 bidders were participated.
Dear Lordship, kindly mention Ferro Alloys Division. Lot 1.
Lot 1.
Ferro Alloys Division.
Lot 1 within bracket.
Ferro Alloys Division.
Ferro Alloys Division of the unit and a piece of land. 23 bidders were participated, and altogether and total 343 bids were received. As regard lot number 2, that is captive power plant. 26 bidders were participated and 420 bids were received. On receipt of the same, it was found that Rungta Sons Private Limited, who is one of the bidder, has quoted rupees 76,78,00,000,000 for the lot 1 and rupees 52,65,68,000,000 for lot 2. The official liquidator, after taking into consideration the reserve price of both the lots, and find that the bidder, namely Rungta Sons Private Limited, has quoted much higher price than the reserve price. Accordingly, the said amount was the said tender was accepted, and the same was duly intimated to the State Bank of India, SAMB.
Yes, Lordship. SAMB 3 Mumbai.
SAMB Roman 3 Mumbai, IFCI Limited, as well as Indian Bank. On receipt of the said bid price, all the 3 banks have conducted a meeting on 21st of March 2025, and all the 3 banks have accepted the rate quoted by Rungta Sons Private Limited with respect of both the lots. The counsel for the State Bank of India has submitted the minutes of the meeting. Let the same be kept with the report. Minutes of the meeting where all the three banks have consented with regard to the rate offered by the bidder, Rungta Sons Private Limited. Let the same be kept with the record. Full stop. Learned Counsel for the official liquidator submits that as all the three banks have also consented by accepting the rate quoted by Rungta Sons Private Limited with respect of both the lots. Accordingly, the official liquidator may be allowed to complete the sale.
Your lordship kindly confirm the sale. Confirm the sale in favor of
Press for confirmation of the sale of both the plots, that is ferro alloys division / unit and piece of land,
yes,
as well as captive power plant in favor of Rungta Sons Private Limited for a total sum of rupees 76,78,00,000, and 52,65,68,000 respectively.
For captive power plant, my lord. That is in respect of lot
Yes,
2.
it's given.
Yes, my lord.
Consider the submission made by the counsel for the official liquidator, and considering the process adopted by the official liquidator and the minutes of the meeting of three banks, this court find that the rate quoted by Rungta Sons Private Limited with respect of both the lots be confirmed.
And my lord, liberty may be given.
Confirmed.
Yeah,
Confirmed.
liberty may be given to the official liquidator, my lord, to release the EMD submitted by the H2 and H3.
Who are the H2 and H3?
My lord, the highest, my lord, the second highest bidder. Yes, in
Who are
respect.
that? There is no name.
SPS. My lord, one is SPS.
You're not named.
Yes.
SPS is still.
Yes.
SPS is still, and both SPS is still.
Sri Nayak Fero. 2 and 3, my lord, page 32. Page
both SPS is still. Here also the alloy wheel also the SPS is the second one, and captive also the SPS is still 5260.
But in Faro mein SFEL metal.
My lord, in the bid one.
Only come to the page 21.
Yes, page 21, my lord, the Rungta Sons Private Limited.
One first.
Then second one, my lord, SPS Steels Rolling Mills Limited. And third one, SFAL Metallics Private Limited.
No.
Yes, my lord, that is.
Yes, sir.
SPS is still.
Yes,
Second, H2.
SPS Steel is my lord the second.
Second. Third is the Rungta Sons.
Yeah, no, Rungta is the first.
Rungta, can you see this? 21.
Yes, page 21.
SPS still is okay. H2.
One is lordship, one is the SPS and the next one is SFAL. So there.
My lord, your lordships kindly take this copy, my lord. It's a clear, my lord. 21 and 32, my lord. Page 21. And
SPS.
Yes.
SPS and SFAL or something.
Oh, where you got?
Second.
SFAL.
Yes.
SFAL.
Yes. And my lord, page 32.
No, I am going the big law.
Yes.
Okay. The official liquidator is granted liberty to release the EMD of H2 and H3.
Yes.
H2 and H3, namely SPS Steel Rolling Mills Limited
and SFAL
and
Metallics Private Limited.
Metallic METALLICS Metallics Private Limited.
And my lord, kindly turns to page 32.
Private Limited and
page 32 3 S3 H3 is different name.
And
Sri Nanak
and in connection with in connection with alloy wheel
in connection with ferro in connection with
ferro alloys division
captive power plant
and and with respect of and to release the EMD of H2 and H3
Yes.
with respect of captive
power plant page
power
8.
plant to SPS Steels Rolling Mills Limited and Sri SHREE Sri Nanak 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 Ferro Alloys Private Limited. Within a period of
within a period of
2 weeks.
2 weeks. 2 weeks.
Within a period of 2 weeks from date.
One small submission, my lord. There are other properties in regard to this company in liquidation, my lord. The directions may be given to the official liquidator, my lord, to take those properties, my lord, on sale, my lord.
Yes, definitely, definitely.
It is not a subject here.
Yes.
My lord, in regard to that same company in
But I cannot say here without the document.
I'm deeply.
So this is disposed of?
Yes, my lord.
So in view of the above,
CA number 10
CA
of
number 10 of 2024 is disposed of.
I am deeply blessed.
With CP number.
Yes.
Connected
No,
with
my lord,
CP.
no, my lord,
Connected with CP number.
Yes, CP is one of
Connected
the,
with CP
it's
number.
like a civil suit.
This is any amount, my lord.
My lord, CP is like suit, my lord.
That's why.
And CA is the
now they
interlocutory
will be
application.
benefited.
Yes, yeah.
In connection with CP number 896 of 2016 is disposed of.
My lord, the CP may be kept on any other day, my lord. The CP, my lord. CA has been disposed of, my lord. The CA9, my lord.
CA9 in CP.
Yes.
In CP. So you want to bring the another application, I will take care of.
Yes.
In this, without the CP cannot take. This court cannot take the CP unless there is an application.
My lord.
Right. Deeply blessed.
Acha. So how many days the highest bidder is to pay the amount?
My lord, that is mentioned in the.
That is not
30
mentioned in
days,
the report.
Yes, my lord. 30 days from the date of confirmation.
The highest bidder of both the properties, the highest bidder, namely Rungta Sons Private Limited, is directed to deposit the rest of the amount with the official liquidator within 30 days from date. Thank you for reminding that. Yeah. हाँ उससे पहले dispose of से पहले.
Lordship, regarding item number 14, Your Lordship, I am seeking time to file the auditor's report. Here, Your Lordship, we initially have taken out an application for seeking for dissolution of 26 companies.
Item number
14. 14, Your Lordship.
Yes.
Subsequent, Your Lordship, by way of a supplementary affidavit, Your Lordship, we are only seeking for dissolution of the 17 companies, but the rest of the companies, Your Lordship, some has gone to NCLT and some are litigated with different reasons altogether, Your Lordship.
So how will go to the piecemeal? So NCLT and this.
Lordship, this only 17 companies, Your Lordship, is absolutely adjudication free. There is no litigation. So, Lordship, regarding those 17 companies, the matter can go for dissolution. There was a direction to file the auditor's report, Your Lordship, but I'm seeking some more time, Your Lordship. That is the only issue here, Your Lordship, at this juncture.
Certificate of the auditor has contemplated so and so shall be filed within in respect of 17 companies whose dissolution is sought for. More discovery in paragraph 14. So you want time?
Lordship, at least 2 weeks. 1 month. Lordship, more than a month, as per my instruction.
So and so appearing for the official liquidator. Official liquidator prays for time to file report. Official liquidator prays for 4 weeks time to file report.
Auditor's report.
Auditor's report. Full stop. In view of the submission made by the counsel for the official liquidator, time to file the auditor's report is extended for a period of 4 weeks from date. This is the matter on 7th May.
Second week of May, Your Lordship.
14th May.
14th May. Grateful. Much.
Yes.
In this matter, I am appearing on behalf of the official liquidator. Lordship, pursuant to the order passed by Honorable Justice Shugata Mojumdar, we have complied the order. But Lordship, what happened in this matter, that our applications was different
Report is just a minute. One report has come on. Let me see.
Please.
Yes.
Lordship, what happened in this matter that pursuant to the order passed by Honorable Justice Sugata Majumdar, we have complied the order. But problem is that, Lordship, our CA is totally different. If your Lordship's
No, in terms of the order passed by this court, the registrar of this court has appointed the CA.
Yes, for
Courts and company.
yes, for dissolution. But Lordship, our prayer was different. If your Lordships kindly come at CA5 of 2022, Lordship. My prayer was. May I read the prayer, Lordship?
Where is the master judge's direction?
Yes. Summons for directions, Lordship.
Yes.
That an order be passed granting the official liquidator to appoint an auditor from the panel maintained for the purpose of investigating the affairs of the company, not for dissolution, Lordship.
You not file an application for review of this order.
No, Lordship, what happened? It's a mistake on our part because we have not.
And already the registrar has acted
yes,
upon,
yes,
and he has
yes.
appointed and informed to
Yes,
you also
But this is a
to contact
technical.
with the Segotion company. Oh, what can be
Lordship,
done?
they have already
Acted
sent,
upon, order acted upon.
Lordship, then what to do? Lordship, I am also very
What
much
is the prayer now?
Lordship, my prayer is still remains in this
So you could have
application.
been informed the registrar. You are not informed the registrar. You kept silent and he has appointed. He has issued the notice to you to
Yes,
contact
yes,
with the
Lordship,
auditor,
yes.
but you have not contacted the auditor. Neither you have given any reply to the registrar also. You could have been informed the registrar not to appoint, or you will take appropriate steps. So what will happen now? And what for the suitable auditor panel so for this purpose?
No, our
And your
application
your
was
concern is
for
the investigation.
Yes, Lordship. Our
Your case is
application
the investigation for misappropriation of the
I
amount.
prayed for in terms of prayer A, B, and C, but
And that is
somehow
12 in February. Now we are on April.
yes.
So what can be done? This court cannot review the order so moto. If you want to review, I will send the matter to the Justice Majumdar. This court cannot take the matter.
I have understood, Lordship, the problem which we are also facing, the same problem, Lordship. We don't have any funds, but Lordship, only these steps, one steps ahead now. But we have to then.
Okay, so now the official this chartered accountant has been appointed. Correct.
Yes.
So now you proceed with that. You request this investigation, and you can modify the prayer subsequently. That
No, in that event, Lordship,
see, in terms of the order dated 12th February, the
Yes.
registrar ordinance head is appointed.
Yes,
The auditor has been appointed.
Yes.
It has been informed to you.
Yes.
Now you are telling that
No, auditor has also prepared a report. Also.
So you request the auditor
Yes.
to investigate into the matter. If not, then you come with the modification. That can be done. Who will give the fees of this advice? As per the prayer made by the consensus and appearing for the official liquidator. Consensus and appearing for the official liquidator. As per the prayer made by the counsel for the official liquidator, the case is adjourned. let the matter appear on 16th.
Yes, 16th of April.
16th April. You take steps immediately because otherwise your time will be over. If you submit the report, then it will be difficult.
No, he has already submitted a report, Lordship.
Report is not here.
No, report is lying with me. Report is lying with me. But without order, how can this the means
You take appropriate steps. After receipt of the order, you fresh cause of action, you take steps. Next.
এক second.
16 malad it's a সবাইকে চলে common submission.
Where is the master direct?
আচ্ছা. Well, 16 is a very peculiar situation. Your lordships will not open 16 to 26. Will lordships, may I request your lordships not to open the file? I am for the resolution professional.
Total bar is appearing.
Yes, but it's a very peculiar case. I don't know why this was not done. I appear for the resolution professional of this company, Avni Projects. Two parallel proceedings are going on now. Just like your lordships observed in the other matter, the one matter before. Winding up order was admitted by your lordships on 1/12/2017. Appointment of provisional liquidator is on 7/9/2018. In between 13th of March 2019, a petition under section 7 of the Insolvency Bankruptcy Code was admitted and CRP was initiated. Now, I'll tell you, Lordship, the confusion was initially all the high courts were of the opinion, initially they were retaining some of the matters. The fresh matters where admission order was not passed, they were remitting it back. First of such judgment came from Justice Shonji Banerjee in the Madras High Court. Then the Delhi High Court followed it. Ultimately, Supreme Court settled the law, said that IBC is a special legislation. Resolution, liquidation should be the last resort. So Jaipur Metals and then Action Butter, everything, Action Ishpat, Action Butter and Action Ishpat, both goes away. Now, my lord, here what it seems like there is a judgment. It's my duty to point it out to the court. Justice Mukherjee's judgment, Arindam Mukherjee's, there was an order passed that, okay, both will continue. That point of time, of course, my lord, the law was something different. That was very different. My lord, what I have done is now, my lord, after as a resolution professional, my lord, it's at a very advanced stage before the NCLT where plans are being called for by the home buyers. Of course, my lord, two parallel proceedings cannot continue. We have taken out an application upon coming to know, upon an attempt being made by one entity to take over the registered office. We have come up with an application that is CA 83. It's not on your lordship's list today. CA 83. With a prayer that the proceedings be transferred to the National Company Law Tribunal as per the law laid down. In that application, we've also asked for recalling of the order, the previous order, where then and the lordships on the last occasion, 17th March, this order was passed by my lord Justice Sugata Mojumdar, and my lord, your lordships would see, my lord, and in fact, there's a typographical error. It should be stayed till the returnable date. It has gone down as stated on the returnable date. It's a typographical error. It should be stayed till the returnable date.
My lord, I have only one objection. If it is recalling, that has to be before Justice Mojumdar. If it is
I am not asking for
not yet made any prayer.
Well, that IACA 83 is listed on 22nd of April. 23rd of April, I'm sorry. 23rd April. That has a prayer for transfer of all the proceedings to NCLT. If that your lordships here, I think all these applications, the series of applications, and I'm really sorry to my learned friends. I feel sorry as an officer of your lordships court that this has to be transferred, the home buyers and everything, all the applications and all. But my lord, two parallel proceedings as your lordships cannot continue. And IBC being a special legislation, I mean, as
After
per
the new amendments,
after everything has to go there. In fact, the official liquidator also, Malas, we have proceeded. We have requested him to hand over, Malas, the documents, everything on behalf. There's an order passed by the National Company Law Tribunal upon the official liquidator. Official liquidator is not appearing, but that's a separate matter. The official liquidator is very much well aware that there is a insolvency proceedings are still going. I do not know. That's why I say it's a very peculiar case. Why, Malad, this was not told, or rather, after the judgments came up on the Supreme Court clarifying the law right now, why this was not told to the court, which is why we filed an application, which is now listed on 23rd. Would your lordships
order was passed in presence
correct
of the RP. So he cannot say that, because at that point when the order was passed, several orders were passed.
By this court.
By this
Yes,
court,
yes, I am myself. I'm telling your lordships that, my lord.
by this court.
In
Now
fact,
they are changing their stand.
No,
How
no,
on earth
no, no,
Exactly,
no.
my lord.
May I say
In
this?
addition
May I
to
say
my
this?
learned friend, in addition to my learned friend, my lord,
For my lord, the registration
of the flats, of the flats.
Correct.
Company cannot
Correct.
claim any ownership. Company was in a development agreement with the owner, my lord, the landowner. During pendency of, my lord, the transfer proceeding, I have given position. But in between, company went in liquidation. And, my lord, at this stage, my lord, the owners retained the ownership, my lord. What we are today praying, my lord, let the.
So who has gone to the company? Who has filed an IBC proceeding?
IBC was filed by, my lord, the secure trade. My lord, we were, my lord, it was never.
Correct, correct.
Never,
All my learned friends are correct.
Lord
And
takes
in
only
fact,
my application CA60, my lord, at page.
seeking a direction by your lordships, my lord, upon them to, my lord, register it.
That's
Because
all.
this company
Correct.
cannot, my lord, retain a proprietary rights over the property. And, my lord, in this matter, my lord, Justice Banerjee has already told that this winding up proceeding should be retained by this.
Justice
honorable-
Mukherjee.
Justice Mukherjee, I stand corrected. Should be retained
And
by
parallel.
And, my lord, the similar order with regard to, my lord, registration being done has also been
Correct.
passed by Justice
Correct.
Kapoor. Lord, today it was passed in his presence, my lord, in 2023 as well. Now he is taking this point, my lord, only to delay, my lord, the
No, no,
process,
no,
because
no.
we are already in the position. Only thing, my lord, we have already paid all the, my lord, the monies which are required to pay. Only relief people which we are seeking, my lord, kindly to, my lord, direct them to register it.
My lord, in fact, there are 3 applications which was allowed by Mr. Lordship Kapoor, my lord, where 3 applicants, being the flat owners, were allowed for registration by the resolution professional or the liquidator, whoever it is. If my lord kindly takes my application only CA60, my lord, at page 123 is the order.
CA60?
CA60, my lord. Item number 16 only.
Page?
Page 123. I'll only place the last paragraph of.
Yes.
My lord, that is paragraph 22. At the end, I hold that this court possesses the jurisdiction to hear out the winding up petition being CP1 of 2016 along with all connected applications. However, the winding up petition and the connected applications thereto should not be proceeded with till NCLT comes to the conclusion as to whether the resolution plan in respect of the said company is either approved or rejected. In case of approval, further orders may be passed in CP1 of 2016 with regard to revival of the said company. In the event the resolution plan is rejected and such rejection order achieves finality, the said winding up petition shall be proceeded by the company judge under the provision of the Companies Act 1956 and rules framed thereunder, and for further course of action as to the winding up and dissolution of the said company. The OL appointed as provisional liquidator shall render all assistance to IRP appointed by the NCLT to giving inspection, supplying the copies of the documents and informations as may be asked by the IRP in connection with the preparation of the resolution plan.
Correct. This is Justice Mukherjee's order.
Justice Mukherjee's order. And moreover, my lord, thereafter, Justice Moshmi Bhattacharya has also passed an order, which is at page 128 of my application.
What is the date of this order?
12 December 2019.
My lord, 12 December 2019.
2019. Yes.
My lord, then at page 128, order dated 20th November 2020.
128.
128, my lord. It starts 128. I'll just place the operative part, my lord, which is at page 131.
Yes.
The intention was very clear, my lord. It is from the in the middle, my lord. It was also decided the question of title to the flats. My lord, it is in the 5th line at page 131. It was also decided that questions of title to the flats, etc., were declaratory in nature and could hence only be decided by this court. So, my lord, today this is the issue. We are all home buyers. We are all flat owners, and maximum of the people has paid the entire money. We are only waiting for our registration.
How many home buyers are there?
My lord, as far as I am concerned, I have 4 applications.
Who has filed this? How many applications?
There are many.
There are many, my lord, many.
But in fact,
all are here.
In fact, this
All
was
are-
a company, because I have to support my learned friends for that. This was a company who has collected crores and crores of rupees from the home buyers. In some projects, development has not even taken place. In some projects, development taken place, but conveyance not done. Possession handed over without conveyance. A fraud of a very serious nature. Now, my lord, NCLT even examining the fraudulent transaction applications and everything over there. Now, I absolutely understand. In fact, applications are also filed before the NCLT also for handover of conveyance, execution of conveyance, and the RP is doing that because the official liquidator cannot do that. But the question is, my lord, let us forget everything for the time being. A different counsel may come before your lordships. may make a submission, and RP may come in submission. But there cannot be an estoppel against a law and against a provision of law. I cannot change the law. My learned friends cannot change the law. If the court today seizes jurisdiction by way of a certain judicial intervention of or by way of a particular legislation, then the court would be, the question is now it's a jurisdiction question. Whether this court retains jurisdiction after what the Supreme Court has said, or whether
when the Supreme Court judgment, what is
yeah, that those are later 2021 is 2020, 2021.
That's why
I'll give you a lot.
That is after the 20th
Yes,
November
yes.
2020.
19 order. 19 order.
19 order, then justice
20, correct. Now,
Bhattacharya is 20.
and so now the question is this, that the question is only this: good or bad, I have filed an application for transfer. Now the question is, yes, I am with my learned friends that these flats have to be conveyed. There are issues regarding some of them, certain payments. If, for example, they have not paid 100% of their consideration, some has paid 90, some has paid 80. So that remaining consideration has to be paid and the conveyance has to be executed. But the question is, the problem that is arising is two conflicting, two parallel proceedings that are going on right now. One is before the National Company Law Tribunal. In fact, the matter was there before the National Company Law. It was taken up, and I was there personally to argue the matter. One matter proceedings going before the National Company Law Tribunal. One is going before the Honorable Calcutta High Court. Which is why, in light of what was been stated today, because if your Lordship sees the Insolvency Bankruptcy Code also, there is a bar even under Section 14 also for continuation of this proceedings. It's a legal bar. I'm more than happy, but then everything has to be at one place.
But that
this
point
can't
has been dealt with.
I'm saying my learned friend is not prejudiced in any manner. What I'll tell you.
Obviously, we are.
No, just a second, my friend, Mr. Vaisya will understand this. What I am saying is, if all these applications are transferred to NCLT, the fate of these applications would be very simple. That flats conveyance would be directed to in favor of them. I'm not saying the outcome of the application will change there. The outcome will remain the same. The conveyance, if they have paid entirely 100%, conveyance is required to be executed. In fact, now the National Company Law Tribunal enclared Supreme Court in the matter of home buyers. Your Lordship knows Supreme Court came down heavy on Unitech, JP and all these matters. Have directed the RPs, NCLTs to pass orders to execute the conveyance in their favor. But the question is, which court now has the jurisdiction? That's the point of law. May I say this, Malad? I know my absolutely right. I am agreeing everything.
17 March, there was a direction for filing evidence.
Yes.
The matter is
correct.
23rd April.
That is what I handed up to your Lordships. Be tagged, you Lordships hear me out. Then Malad, your Lordships will keep everything on the 23rd.
So come on 23rd with all
and with all the applications, your Lordships will hear me in CA 83 as the lead application. If I succeed, then matter gets transferred. If I do not, then all these applications will be allowed.
My lord, in fact, no copy of the application has been served upon us.
They are not parties there. I have only made
prejudice. Obviously,
in 83, you have filed the application.
Yes, it's on a point of law.
Who is the other party?
Well, the other party is the official liquidator.
Have you with regard to the home buyers?
The home.
Not received.
May I say this?
23, my learned senior friend has had his say, my lord, will kindly take into consideration the position the home buyers are in.
No, that's correct. We see now so many analogous applications are there. Now the only point is to be taken into consideration whether this court pass any order or whether this court has to transfer to the IRP.
Correct.
My lord, we bow down to that, but my lord will also take into consideration, my lord, that the submission that is coming from the RP is being taken at this fact end of the moment.
No,
my lord will
correct. That's why the piecemeal it cannot be. In one matter already there is a affidavit directions are there. Let the affidavit be filed.
It's on a point of law.
Let all the things be
Like, I am not.
This was never taken. My lord will kindly take up the order passed by Justice Kapoor, my lord,
which I had handed over.
22nd May 2024.
Kindly take the second paragraph.
I am a very bad person. I understand it. I have not taken
any allegation, but allow me to submit. My lord, this cannot be a one-way street, my lord.
A one-way street. What are you? Go on. You're junior to me, but go on. Go on, please, sir.
No, in that case, the official liquidator and the resolution professional are also represented and do not object for the prayers.
Yes, my lord. Correct. They did not object.
Correct, and I have asked for a recalling of that also. Before that, I have asked.
Lord, flat is
just one. Yes.
Lord, may I say this? there are many applications of flat buyers. Mr. Dasgupta was there in court that day. He kept on asking those applicants, what are these applications for? What are these applications for? We had no idea about that because I am the RP. And my lord, I am again saying, in principle, I have not even seen these applications, but I can convince about my clients this, that these applications are for conveyance to be done. It has to be done and it will be done. There is no question of delaying. The question is, my lord, if my learned friend's case is RP was present throughout, XYZ person was present throughout, this point was not argued. But my lord, even if this is not argued, this is a point, this is a jurisdictional point. I cannot waive off jurisdiction.
How many you have any details? How many applications so that I can keep all
Many,
the
16 to 26. 16
Mr.
to
Dasgupta,
26.
you are having this one. Any
16 to
other
26.
pending matters are there?
Other we will also check.
You do
In
one
the
thing,
meantime,
what are the application? Give the number to my court officer.
Court officer.
In the company department.
Yes.
In the company department to give them, and they will list all the matters on 20.
Let me say this: CP1, any applications connected to CP1 of 2016 may be listed on 23rd.
Correct.
Your lordships can pass as $1, and if and I tell your lordship, I'll only argue vis-a-vis this transfer. It's on a point of law. I may not have even filed an application also for that effect. It's on a point of law, but it was required to recall that order by which the registered office was directed to be handed over to from the official liquidator to Reliance. That's why I've asked for recalling there as well. That's why I've served Reliance as official liquidator. But I am not, even once when I argue on the point of transfer, will I show something from the application at all? I'll just show those two judgments and the CRP admission order.
Yes,
I'll give them a copy.
I just had applications in which the order was passed in favor of the purchaser.
No, I did
Correct.
not.
That's
what
why.
I'm
That's why.
saying.
By consent of the RP.
That is there. This
Exactly.
is the Justice Kapoor order is
Yes.
there.
Well,
at page
So
3
that's
only.
why what I propose to do, subject to let all the connected application in CP1, 1, 2, 20, 30, whatever is, let all the matters come on 23rd. Correct. 23rd, whatever the judgments you are relying upon, consent order or the with regard to the unmarried, let you come place before this court. He will place before this court. Let the court decide.
My lord, in the meantime, I also request them to serve a copy upon us, so at least we can deal with that.
Serve a copy of what?
What a copy?
The application of what they have filed.
They are not a party there.
But we are.
But it's on a point. Then there'll be hundreds of people.
We are being prejudiced.
No, I'm not arguing a point of law. I'm saying that's
You
what
are
I'm saying.
appearing to whom?
My lord, I am for the home buyer.
Which matter?
Item number 16.
That's
And
all.
also 21, 22, and 23.
So he's there. He'll
You
be
are
present
there.
in court. I'll argue on a point
You
of
are
law.
there.
My lord, I am there, but I don't know what contentions they have made in their application.
This is a point of law. That's why he has raised 2 points. One is with regard to the jurisdiction of this court. Second point is the other orders which you are relying upon, that is prior to the order of the Supreme Court. And whether the similar proceeding can be go with the parallel
My
proceeding.
submission is, the order of my Lord Justice Mukherjee. Well, that's the major attraction because that said that retain it, and subsequently that's been going on.
That's why.
Correct.
So, to Justice Mukherjee and Justice Bhattacharya's order is after before the Supreme Court order, then the situation would have been difficult. And with regard to the Justice Kapoor
Even
order,
if
that
it
is
is-
with regard to the consent
Correct.
order.
And
So
even
that
if it
has
is
to be dealt with.
correct, even if it is, I'm saying, and said consent is regarding what? Conveyance. I'm not on the.
That's
on
why
that point.
conveyance.
Correct.
So conveyance also, whether now at this stage after the order of the Supreme Court, whether this court can take the consent of the
Because your lordships always tells us, can I by consent confer jurisdiction upon a
That's
court?
why.
which
That's
does
what
not-
telling.
I
The
cannot do
consent,
so.
the
I
judicial
cannot do so.
cannot be
And
conferred.
even if I've given, I cannot do so. I cannot give an illegal consent.
Lord,
also.
but as far as Justice Kapoor order is concerned, it is not a consent order. If your lordship can, page 3, page 3, my lord.
My lord, I am agreeing with everyone. There is no dispute.
Page 3, second paragraph. Page 3, second paragraph of Justice Kapoor's order.
Page 3, last paragraph. The official liquidator and the resolution professional are also represented and do not object for the prayer sought for the application. What further remains?
My lord, submissions is also made where it was held.
Maybe, but subsequently last yes, we are ready to register the deed.
So, three deeds has been registered by virtue of orders passed by Honorable High Court.
Lord, I was not there, so my friend will explain.
The learned judge was taking up this determination, asked me to take a sympathetic view towards the home buyers because they have given all their money. They've got the flats. They have not got the deed
No,
registered.
that's correct.
That is why
That sympathy also, this court is also having that.
May I-
But now if the jurisdiction point is there, the jurisdiction
I say
point has
this?
to be
May I say
decided.
this? That's exactly what I'm saying. If your lordships want to even prepone this and hear it up before date, I do not have any problem. I am saying that your new lordships will record my concession also regarding that after taking care of the jurisdiction point, that the RP has no opposition to Malad's executing conveyance deed in favor of the home buyers who has paid 100% consideration. Your lordships will record that also because as an officer of the court, I cannot.
If this statement is recorded and
He's protected
remanding
in NCLT
sending
also.
the matter to the NCLT and you pays the order and they
He
cannot.
just has to pay
cannot go
100%
back
of the consideration.
My lord, there will be one difficulty. If I say something outside the law, my lord, a committee of home buyers will be constituted. My lord, today the home buyers have already paid their money long back and they're waiting only for the conveyance to be executed.
Registration, yes.
Because unless and until if the title is not transferred, they are not having the absolute ownership.
Correct.
Their money is being blocked.
Correct.
Some people has obtained some flats on loan. Home
Correct.
loan, my lord, they are paying interest and everything.
Correct.
Today, if this matters goes before the NCLT, my lord, again, I am being very candid and saying something outside the law.
Correct.
My lord, a home buyer committee will be constituted. Again, the same issue, meetings.
No.
That, my lord, this will take unnecessary time, my lord.
No.
This will take unnecessary
No.
time.
May I say this? May I give a solution? From 16 to 26 today, 16 to 26 today, whosoever are the home buyers, I will request my learned friends to give respective friends to give a one-pager note to us that this is the money paid, this was the consideration amount. If 100% is paid, well, the RP will then, on the basis of that, your lordships can pass a common order, record the concession. They did not be part of the COC because they do not have a claim. They only have to get a flat registration. They're already staying there. So only registration. So
RP will make an
that's
request,
right.
so
RP
the NCLT will pass
not
an order.
NCLT will pass an order, but NCLT will definitely pass an order in this application. But RP will give that concession
That's
here itself.
And my lord, there is even one more aspect to this. It's twofold thing. My lord, Avni project, which is into liquidation. So my lord, if takes any format of the deed of conveyance of what was executed, my lord, the property was owned by Electrical Manufacturing Company Limited. And there was one company which was Metland India Limited, and one was Avni Projects and Infrastructure Limited. So, my lord, as per the development, maximum of the allocation was with Metland India Private Limited, and something was with Avni. So, my lord.
So who will
for Metland
execute the conveyance deed?
My lord, it's only Avni is going to execute it because since they are the developer.
That's
but
why.
Now what has happened?
Why are you going that side? You're going on a dangerous route. I am saying, my lord, I'm trying to assist my friends here. If Malad, let them give a note.
Four application is with me. 4 home buyers are with me, my lord. I can only supply the details of those
yes, those give it and
sense appearing for the official applicant. Sense of appearing for the RP. And sense appearing for the official liquidator. Full stop. It is informed to this court that in connection with CP1 of 2016, several applications have been filed, several connected applications have been filed, out of which item number 18 to item number 16 to 26 are listed before this court today, and other matters are not listed. Accordingly, the department is directed to place all the connected application in CP number 1 of 2016 before this court on 23rd of April 2020.
Along with CA 83, which is already directed to be listed on 23rd.
It is further found that
The order dated 17th March.
that one application being CA 83 2025 is also filed in connection with CP1 of 2026, wherein this court has directed pass a direction for affidavits for exchange of affidavits and to be listed on 23rd of April 2025. In view of the above, CP number 1 and all connected application filed in connection with CP 1 of 2026 along with CA 83 of 2025 filed in CP 1 of 2026 be placed before this court on 23rd of April 2020.
I'm so grateful. Because I'll try to come up with a short notes on that day with the
Come and you all home buyers also come with the amount.
The amount. But just why just want this, because most of these, for some 100% payment has been made.
Correct.
For some maybe say 200
or to exchange
20% exchange that, so that
My lord, the RPS written, my lord, the respective advocate on record, my lord, to mail to ascertain, my lord, and obtain, my lord, the money received.
Very well, very well. That's
In fact, the
very well.
liquidator is supposed to file a report in which whatever the amount is due, he'll intimate and we'll pay it.
Okay.
Very well, very well. That's what I'm saying.
Come on that day, we'll see to this.
To find a solution for them.
Yes, next. 27.
For the company, my lord.
For the company?
Yes, my lord.
What is your prayer?
27, 28, my lord. But the matter was dismissed for default long back, and there are 450 days delay, and they have made us for Section 5 application.
You have filed?
No, they have. My lord, I'm for the company.
Who?
The petitioning creator, one Mr. Guddu Singh, and my lord, that too, my lord. Even I can say, my lord, there is a false statement made.
None appears on behalf of the petitioner, creditor, nor is any accommodation. None appearance on behalf of the petitioner, creditor. Stand dismissed. Nobody is there.
Grateful.
So appearing for the appearing for the company. None appears on behalf of the petitioner.
Petitioning creator.
None appears on behalf of the petitioner. None has moved the said application. Operate for any accommodations. Accordingly, CA1 of 2024 in CP 119 of 2016 is dismissed for default.
Same one is the Section 5 application.
2728 both.
Both.
29, I am for the official liquidator. I am filing a report lodge.
Yes, which for the applicant?
I have the respondent number 2 in CA.
Which for the applicant?
Lordship, this is my application, Lordship.
Official liquidator?
Yes, Lordship.
What is the prayer? What is the prayer?
One is for security agency that they are not paying security expenses, and another is, Lordship, there was some. If your Lordships kindly come at page 21, Lordship.
Page 21.
Yes, Lordship.
Of CA.
CA 13, Lordship.
CA 13, yes.
That in compliance, paragraph 30, Lordship, that in compliance of the said order, this office violated dated 7th February 25 served copy.
Page.
Page 21, para 34, Lordship. CA 13. This is
Page
a report,
21.
Lordship. This is a report and Lordship.
Page 21.
Yes, Lordship. And my
page 21. Page 21 is your prayer for in this application.
No, Lordship prayer, page 18. This is a report which I was reading, Lordship. This is an application page.
No, where from your reading? Report?
No, yes, Lordship. Report.
So today which you have filed?
Yes, Lordship, that one.
Page 18.
Yes.
Yes.
Have your Lordships got
page 18?
Yes, paragraph 29. Yes.
Paragraph 28. 29 is page 19.
Yes, sorry, page 17, Lordship, paragraph 26, Lordship.
Yes.
That the applicant states and submits that the secured creditors are not paying their proportionate share of security expenses in time, especially IFCI and RCL. The total outstanding dues of the secured creditors up to February 2025 are as follows, Lordship. These are the secured creditors. There are 4 secured creditors, Lordship. Out of them, only 1 secured creditors are paying and others are not paying.
Who is paying?
Lordship, which I have given, that proportionate RCL RCL is paying this one lakh proportionate amount to be paid. Yes, RCL is paying, isn't it?
Amount yet to be paid by
IDBI.
secured creditor.
IDBI.
IDBI.
IDBI is paying, Lordship. And
IDBI.
RCL, Allahabad Bank and IFCI are not paying their dues. If your Lordships kindly see their dues, Lordship.
All are default.
Yes, Lordship.
Arcel is 1 lakh,
Yes.
1 crore, 3 lakhs,
Yes.
13,000. Allahabad 1 crore, 27 lakh.
And Lordship, in spite
No,
of
1 lakh
several-
27,000. And IFCI 1 crore 88.
Yes.
IDBI 4 lakh 4,000.
Yes, Lordship.
So
But
the total security expenses 4 lakh 4,000.
despite of several letters, Lordships, they are not paying. And there
what
is
do you
an
want?
order of the appeal court that they have to pay within 10th of the month, but they are not
So
paying.
what is the prayer? Where is, that's why I'm asking, where is the prayer in the application CA? Where is the judge's direction? There is no judge's direction.
If your Lordship kindly give me one.
First one.
Yes, Lordship. Page 20 of my application, Lordship.
No. Direction be given to the secured creditor of the company to pay the outstanding security. First, have you issued the notice to him?
Several
Where is the
times,
affidavit of service?
Several times, Lordship.
No, after this CA notice.
Yes, Lordship. Several times we have.
Where is
served
the
them.
affidavit of service? Direction given to the secured creditor of the company to pay the
If your
monthly.
Lordships gives a direction, then again I will serve upon them.
So you're not paid for.
Yes, Lordship. 7th February 2025. Yes.
So file the affidavit. No. Where is the notice service?
First page.
Delivered. You file the affidavit. File the affidavit service.
Yes.
Come on the next day affidavit service, or you will issue the fresh notice.
No.
So what is the date? What is the date mentioned in that? Don't.
7th February 2025, Lordship.
You issued the notice.
Herewith the wave text copy of the order 22nd January 2025.
22nd January 2020.
2025.
Yes. Fixed on 6th March.
6 months.
Service
Again, I have to serve them a notice, Lordship, or a
do
web
one
text?
thing. I am fixing a date.
Yes.
You served not to notice, only serve the notice informing the next date of hearing. And I file the affidavit of service on the next date. If they will come, then
Yes.
so and so appearing for the official liquidator. None appears. You are appearing for?
I am for respondent number 2, my lord.
Who are you?
IFC Limited, my lord.
So and so appearing for the respondent number 2.
My lord. Industrial Finance Corporation of India.
Namely, Industrial Financial Corporation of India Limited.
I have to file a report.
IFCIL. Police. None appears on behalf of the other respondents. Police. In terms of the order dated 22nd of January 2025, the petitioner has the applicant has served the notice upon the respondents, but in spite of service of notice, none appears on behalf of the respondent. Accordingly, for the interest of justice, the petitioner/applicant is directed to send a notice informing the next date of hearing, send the notice to the respondents informing the next date of hearing of the present case, and to file affidavit of service on the next date fixed. It is made clear that on the date fixed, if none appears on behalf of the respondents in spite of receipt of the notice, appropriate order will be passed. This is the matter on 23rd
April, Lordship.
23rd April.
Publish.
Next.
Lordship, last matter is also mine. I am appearing on behalf of the official liquidator. I am filing a report, Lordship. 31. 30 the same. Same.
अच्छा,
29, 30 same.
And prior and also you have submitted the report, na?
Yes, Lordship.
उसमें recall first में ना, the official liquidator has submitted the report. Let the same be cut with the report.
Yes, Lordship.
The official liquidator has submitted the report. Let the same be cut with the report.
Well,
Yes, in this 30. Where is the report?
Same application, Lordship. 29 and 30.
29 and 30.
Yes.
29, 30 same order.
Yes. And
31, my lord, this is my application for the dissolution of the
Lordship.
transferor companies with the transferee company. My lord, the scheme of amalgamation has been sanctioned. The official liquidator was required to file its report.
Lordship, I am filing this
Yes, my lord.
report on behalf
They have
of
filed report, my lord, and their report, my lord, page number 7, my lord. They do not have any objection if the transferor companies are dissolved without winding up. And
Without winding up?
Without winding up, because the scheme of amalgamation was passed, my lord.
Only amalgamation was there.
Scheme of amalgamation was sanctioned by this honorable court, my lord. Then this application has to be filed. Kindly see, my lord, their report at page 7, my lord. Page 7, paragraph 4.
Paragraph
4, my lord. That after scrutiny of the report submitted by the chartered accountant and other relevant papers, records submitted by the advocate on record of the petitioner, official liquidator is the opinion that the affairs of the above noted transferor companies,
namely
transfer
Bhagirathi
company,
Vyapar Private
1 to
Limited,
1 to 4, my lord, have not conducted in the manner prejudicial to the interest of their members of the public. The honorable court may be pleased to fast for the orders. Well, at this stage, my lord, I am praying for the prayer C and D in terms of my judge's summon.
officer and director to file the report. Report has come.
Yes, my lord.
B has come. C.
C,
the transferor company, namely so and so be dissolved without winding up
from the date of the filing.
From the date of filing of the certified copy of the order upon the registrar of companies.
By the transferee company. Ajana is the transferee company, my lord. This company will remain. Other 1 to 4 will be merged.
4 will be merged with the Anjana.
Ajana, my lord. And the registrar of company shall place all the documents and all the documents of the transferor company be consolidated with the transferee company after filing certified copy of this order.
Yes, that's all.
Yes, it's a formal application, my lord, after sanction of a scheme. My lord.
Yes, madam.
We don't have any objection.
So and so appearing for the applicant. So and so appearing for the official liquidator. Official liquidator has filed the report after serving the copy to the learned counsel for the applicant. Let the same be cut with the record. In the report, the official liquidator has stated as follows. Paragraph 4, page 7, this one. So set out कर दो, Full. So number. Counsel for the applicant submit that. As per the report submitted by the official liquidator has no objection for amalgamation of the 4 companies with
dissolution of 4 companies without winding up.
Dissolution of the 4 companies without winding up. 4 companies namely Bhagirathi Vyapar Private Limited, Laziz Commercial Private Limited 2, उसको फर्स्ट वाला को नंबर 1 देना. Bhagirathi 1, number 2 Laziz Commercial Private Limited, number 3 Loharuka Estates Private Limited, and Sadabahar Delcom Private Limited be dissolved without winding up the said company. Full stop. Consider the submission made by the counsel for the applicant, and after perusing the report submitted by the official liquidator, prayer C and D of the judge's summons is allowed. CA number 1 of 2024 in connection with CP number 895/2016 connected with CA number 658 of 2016 is disposed. I'm grateful.